Okay. Uh, can you guys hear me?
We're ready.
Okay. I just wanted to make sure we're good to go. Okay. Well, good morning. I am Shane True, Chairman of the Environmental Quality Council. This meeting is being held at the Hathaway Building in Cheyenne and virtually via video conference. It is 9:04 a.m. on August 15th, 2024. Present today, if I can see on the screen, JB Radakovich, Marge Bedessem, Stan Blake, Ryan Green, Steve Lenz, and Bill Stafford. Also present are council staff Kelly Duran and Joe Girardi. On EQC, legal counsel Ryan Shellhouse. And before we get started, I would like to ask for a motion to go into executive session for legal advice.
Yeah, it was moved. Shane might not have been able to hear me.
I've not heard.
Mr. Chairman, it's been moved and seconded.
Okay. It's moved and seconded. All those in favor, please say aye.
Aye. Aye.
Any opposed? Okay, the council will now move into executive session for legal advice. And so maybe hearing room, and returning we're done.
We're in executive session. Okay, great.
We are still in executive session.
All right, are we all back ready to go?
Mr. Chairman, I think Mr. Blake has stepped out. Yep,
Okay,
we're all back now.
okay, we're ready to go. Okay, well, we are back from executive session. First on today's agenda is a final contested case hearing in docket 24-1601. And I will now turn the gavel over to Ryan Green, who is the hearing examiner on this case.
All right, thank you, Mr. Chairman. So we are going on the record in docket number 24-1601, Black Hills Bentonite permit to mine number 248C, Murphy Creek update area, petition for order in lieu of consent. My name is Ryan Green, and I am the hearing examiner appointed in this matter. This hearing is being held in Cheyenne, Wyoming, and present today are council members Shane True, J.D. Radakovich, Marge Bedessem, Stan Blake, Steve Lenz, and Bill Stafford. Also present are council staff Kelly Duran and Joe Girardin and EQC legal counsel Ryan Shellhaas. We are here today for the final hearing in this case. At this time, will the parties please state their appearances for the record, and we'll begin with the petitioners.
May it please the council, Mr. Hearing Examiner, my name is John Masterson. I'm with the law firm of Wellborn, Sullivan, Meck, and Tooley out of Casper. And I am here on behalf of Black Hills Bentonite.
My name is Kayla Albertson. I also am from the firm Wellborn, Sullivan, Meck, and Tooley, and I am appearing on behalf of Black Hills Bentonite.
My name is Patrick Tolley, also counsel for petitioner.
All right, thank you, Ms. Albertson, Mr. Tolley, and Mr. Masterson. And now for the respondents.
Thank you, Mr. Examiner. Counsel, my name is Mitch Edwards. I'm with the law firm of Nicholas and Tangeman. I'm here today on behalf of the respondent landowners, the Perna case.
Thank you, Mr. Edwards. So I want to remind everyone not to speak over one another. We have a court reporter transcribing these proceedings, so it's important that only one person speak at a time so that we can make an accurate record. And just a reminder, if you are speaking today, please state your name clearly and fully for the record. The purpose of today's hearing is to make a determination on the petition for an order in lieu of consent that has been requested by the petitioner, Black Hills Bentonite. The petitioner bears the burden of proof in this case, and they will go first, followed by the surface owner, Bruce and Betty Jean Bereknes, and then the petitioner will have an opportunity for rebuttal. The ultimate issue to be determined today by the council is whether Black Hills Bentonite is entitled to an order in lieu of consent, which requires the council to determine whether Wyoming Statute 3511-406B11 or Wyoming Statute 3511-406B12 applies, and if 406B12 applies, whether the four elements in B12 A through D are satisfied. I understand that the parties have come to some preliminary agreements as to the timing for their presentations today. Black Hills has requested 15 minutes for an opening statement, and the surface owners have requested 10 minutes. Both parties have requested 20 minutes for closing arguments, which will include any rebuttal time to be reserved by Black Hills. That is fine with me, with the understanding that the council wants to move into deliberations no later than 4 p.m. today, and I'm going to rely on the parties to manage their time accordingly. I will note for the record that the parties have stipulated to the admission of several exhibits. Black Hills Bentonite, Exhibit A, patent number 117695. Exhibit B, Bethlehem Steel Company warranty deed dated December 24th, 1957, and recorded in Johnson County as instrument number 76324. Exhibit C, Black Hills Bentonite warranty deed dated April 17th, 1991, and recorded in Johnson County as instrument number 490529. Exhibit D, Fernekis, I apologize, Fernekis warranty deed dated December 18th, 2013, and recorded in county as document number 134738. Exhibit E, 1961 deed dated July 31st, 1961, and recorded in Johnson County as document number 94523. Exhibit F, permit to mine 248C, Murphy Creek updated area 2021 mine plan revision. Exhibit H, letter to the correctnesses from Black Hills Bentonite dated August 24th, 2021. Exhibit I, letter from Mitch Edwards to Black Hills Bentonite dated December 3rd, 2021. Exhibit J, letter from Mitch Edwards dated April 25th, 2022. Exhibit K, certified mail dated August 25th, 2021. And exhibits from the surface owners, Exhibit 1, land records deed chain of title of landowners. Exhibit 3, mine plan June 2021 submitted by applicant to landowners. And Exhibit 4, reclamation plan August 2019 submitted by applicant to landowners. These exhibits are admitted and have been published. Now, before we begin, there are two pending matters that I will address before we get started. First is the petitioner's notice regarding landowners' failure to respond to Black Hills Bentonite discovery request. I have read the motion and I'm going to give each party 3 minutes for an oral argument. So at this time, Ms. Albertson, Mr. Tolley, Mr. Masterson, you will have 3 minutes and you may begin when ready.
May it please the council, Mr. Hearing Examiner, I believe that the briefing we did on this topic is concise. I believe it's very clear from the Wyoming Rules of Civil Procedure, which govern your proceedings, that the failure to respond to requests to admit, if you do not respond as directed, those are deemed to be admitted. It's as simple as that, and that no responses were ever received. So the council should find clearly under the rules of civil procedure that the request for admission that we submitted should be deemed admitted. That is our argument. We feel it's very clear and very straightforward, Mr. Hearing Examiner. Thank you.
Thank you, Mr. Masterson. And all right, let's see. Mr. Edwards, you will have 3 minutes for a response.
Sorry, I turned it off.
I can't hear him.
I'm sorry, I turned the mic off. Red to me means off instead of go. So
Yeah.
I apologize for that. Thank you, Mr. Examiner and members of the council. Mitch Edwards, on behalf of the landowners. Our response to this is the motion is misplaced and incorrectly argued. The order of this council was that the discovery needed to be completed by July 25th of 2024. The rules of civil procedure provide that when discovery is submitted, that the responding party has 30 days to respond to that discovery. The petitioners in this case served their discovery requests on July 24th on the landowners meaning under their argument that we would have had less than 1 day in which to respond. My understanding of the rules of civil procedure and the orders under which discovery deadlines are set is that the discovery requests, if they're written discovery, should be sent early enough that the full 30 days is allowed for the response. In other words, in this case, the petitioner should have sent their discovery request if they were going to send any on June 25th in order to meet the July 25th discovery completion deadline. So the discovery that the Black Hills sent out was untimely, and our response is not yet due. And frankly, our response would have been that it was untimely and should not be allowed. And so we'd ask that you deny this motion. And that's all we have, Your Honor. Or sir.
Yeah. Thank you, Mr. Edwards. And Mr. Masterson, I'll give you 1 minute for a response.
Hearing examiner, this is John Masterson. Mr. Edwards is, the problem is that the rules of civil procedure do not set out that you have to submit your requests within the time period of the discovery cutoff. And you can see that same problem reflected in the council's order setting pre-hearing conference at page 3, paragraph 7. All discovery must be completed on or before July 25th, 2024. What does that mean? Does that mean discovery sent out? Or does that mean discovery sent out and the response is received? So there is ambiguity. I feel that we sent the requests out appropriately, and more importantly, no communication has ever been received asking for additional time, seeking clarification, or anything else. Mr. Edwards is not obliged to do so, but those kind of things, I think, weigh in favor of the council upholding the rules of civil procedure and deeming those things admitted. Thank you.
Thank you, Mr. Masterson. I've had the opportunity to review the motion and hear the oral arguments. And look, I agree with Mr. Edwards. They have 30 days to respond based on the law. My order didn't shorten the deadline. It set a deadline. And, you know, I feel that you had responded too late. So I'm going to deny that motion. Okay. The next matter, moving on, the next matter is petitioner's objection and motion for reconsideration regarding order following pre-hearing conference. Again, I'll give each party 3 minutes for oral argument. Mr. Masterson, you may proceed.
This is John Masterson, Mr. Hearing Examiner and Counsel. Things like this are very, very difficult to submit because I'm coming to you and I'm saying, I think you made a mistake. By doing that, that is not a sign of disrespect for your decision, for your consideration. That is a sign that we believe that the law is on our side. We believe it is clear, and we feel that it's appropriate to bring our concern and our beliefs to your attention because we are making a record here that will need to be reviewed. That record, by the rulings that the council has issued, we will be kind of cut off at the knees with what we feel we have as legitimate and strong arguments that resolve this well before getting into a debate about statutory construction. I do not believe that, with all due respect, Mr. Hearing Examiner, that there is authority within the hearing examiner, because remember, we're objecting to the order following the hearing, where we have been limited in what we can argue. So I guess it's more directed, I guess, towards you, Mr. Hearing Examiner. With all due respect, when I look at the statutes, I do not see the authority that you as a hearing examiner have to make those determinations and to tell Black Hills Bentonite that what it feels is a valid, sustainable theory cannot be submitted to the council for its consideration. As I said, sir, it's a very difficult argument, and I do make it sincerely with all due respect. But that's our position. We just feel it's in error.
All right. Thank you, Mr. Masterson. And Mr. Edwards, you have 3 minutes.
Red means go. Thank you, Mr. Examiner. Council Mitch Edwards on behalf of the landowners. The order following the pre-hearing conference, we believe, sets out the proper law, proper procedures, and is in conformance with what was discussed at the pre-hearing conference. The law is pretty clear. The petitioners here have petitioned under 3511-40C-B12 for a order in lieu of consent. That is only available, and the council only can have a hearing if the first part of that statute is true, and that is for any application filed after March 1 of 1975, including any lands privately owned but not covered by the provisions of paragraph B11 of this section, an instrument of consent from the surface owner, if different from the owner of the mineral state, to the mining plan and reclamation plan. If consent cannot be obtained as to the mining plan or reclamation plan, or both, the applicant may request a hearing before the Environmental Quality Council. The council shall issue an order in lieu of consent if it finds, and then it lists it out. In other words, what the petitioners are now trying to argue is that a deed constitutes consent, that they have consent, they don't need an order in lieu of consent, in which case they're essentially arguing to this council that they don't have to go under B12 and that the council shouldn't even be having this hearing because they already have consent. So either they have consent and this council has no jurisdiction for an order in lieu of consent and to have this hearing, or they don't have consent and then they have to follow the statutory language that's set out and what we believe is properly set out with respect to the order following the pre-hearing conference. What they are essentially asking for is a declaratory judgment that their deed does not constitutes consent and they're not required to provide the consent that's set forth in the statutes. And we don't believe that this council has that authority under these statutes because it only has authority to have this hearing if there is no consent. Thank you.
All right. Thank you, Mr. Edwards. Mr. Masterson, you'll have 1 minute for a rebuttal.
Thank you, Mr. Hearing
Response.
Examiner John Masterson. The statutes clearly do not contemplate a situation like the one you have before you, where in 1957, all of these rights, consent, access, production, all of those things were given away. And they were given away to Bethlehem Steel, and then Black Hills Bentonite acquired all of those things. The statutes, they don't contemplate this. Nonetheless, because we have a situation where you have a surface owner and a mineral owner, you have to get consent. You know, that's something that that we are required to pursue. The thing is, and you're going to hear a lot about alternative arguments. Attorneys do this all the time. This is, if not standard, it's expected, mandatory. The statutes eclipse, or excuse me, let me try again. The legal issue of the deed and the rights that Black Hills Bentonite holds precludes the application of any of these statutes. You don't go there. You find the Black Hills Bentonite owns these things. And that is your surface owner consent, because they own all these rights. Mr. Furnicase and Mrs. Furnicase do not have the ability to withhold consent. They don't have it. And if you find that, we're done. But the statutes mandate us, if we do not have consent, which we tried to get, you'll hear testimony about that. If we don't have that consent, we have to come to you. That's why that's part of the reason why it simply does not fit. We need to be able to make a record. We need to be able to submit this and give you evidence and testimony about it so you can consider it. Should the council decide that that argument does not carry the day, it can then proceed to the statutory analysis that Mr. Edwards refers to. But certainly we should be allowed to present our case. Thank you.
Thank you, Mr. Masterson. So I've had an opportunity to review this motion and hear oral arguments. Black Hills Bentonite came to the council on March 15th, requesting relief in seeking an order of lieu and landowner consent under Wyoming Statute 3511-406B12. And so in that, there is some language that says with except for these land conditions and landowners. And so I feel that the burden of proof is on Black Hills Bentonite to prove why that doesn't apply. And so with that, therefore, the motion for reconsideration is denied. Okay. Are there any other issues that need to be addressed at this time before our opening statements? Mr. Masterson.
This is John Masterson. Thank you, Mr. Hearing Examiner and members of the council. I do have a few preliminary matters. I need to ask Mr. Hearing Examiner, we need to build our record for the argument that I understand your ruling. I respect your ruling. I don't know if your ruling means we cannot get into that at all, or whether you will allow us to do that, but instruct the council that that's not an avenue they can proceed down. So I had a couple other things I can do right now, or we can talk about that.
Sure.
The first thing I wanted to do was introduce the other people, the non-attorneys who are here on behalf of Black Hills Bentonite. Mr. Larry Madsen is a witness and will be testifying. Doug Gibson is also a Black Hills Bentonite employee. He will be testifying. They've both been identified in our pre-hearing statements. I wanted to make sure you knew who they were. You've been given a binder of stipulated exhibits. Those are hard copies of what's been electronically filed. I believe Mr. Edwards will confirm he had the chance to look at that and confirm that that's true and accurate. It's for your use if you want a hard copy. I'm assuming also, Mr. Hearing Examiner, you'll proceed standard fashion with Black Hills Bentonite. We'll call our witness. We'll examine Mr. Edwards.
That's correct.
Standard
Yes.
trial type
That's correct.
practice. Thank you. I think that's what I have. Thank you, sir.
Right. Thank you, Mr. Masterson. Yeah. Okay. And Mr. Masterson, we will you proceed with your evidence, and we'll take it as it comes into consideration. But please, I will remind both, we want to stick to the question is, is it relevant to whether or not B12 or B11 apply? So, but we'll take those as they come in. Any objections Mr. Edwards might have.
Mr. John Masterson, Mr. Hearing Examiner, thank you. And we do appreciate the time constraints, and we're aware of them. And I don't think it will unduly complicate or lengthen anything. Thank you.
Okay, Mr. Masterson, you may proceed with your opening statement. You have 15 minutes. You can proceed when you are ready. Ms. Albertson, I'm sorry.
You're okay. Kayla Albertson on behalf of the petitioner. Good morning, members of the council. As you're all aware, Black Hills Bentonite has been mining and processing bentonite for decades. They've also held the mineral rights to this land in question through the deed at issue. We're here today because my client, in exercising its rights, is seeking an order in lieu of surface owner consent to proceed with the mining activities on this parcel. Before we begin today, as Mr. Masterson has discussed, as attorneys, we tend to, argue out of both sides of our mouth. We try to work two tracks at the same time to ultimately get to the conclusion that we're looking for from you. I understand the emphasis needs to be more on the statutory application in this matter, and so I'll do my best to adjust as we continue throughout the day. It's really important to emphasize that the mining rights held by Black Hills are not recent acquisitions. They've been rooted in this deed, which explicitly grants Black Hills the ownership of the bentonite, as well as the right to enter and use that land as necessary to extract those minerals. As part of this statute, under 3511-406B, both 11 and 12, the statute states that for an application after March 1st of 1975, the applicant is required to produce an instrument of consent from resident or agricultural landowner if it's different from the owner of the mineral estate, which we all agree that we do have a split estate here, which grants the applicant permission to enter and commence surface mining operation, and also a written approval of the applicant's mining plan and reclamation plan. When you read the statute along with the deed already contains the language granting the permission to enter the land to mine the bentonite. What we're needing is that written approval of Black Hills mining plan and reclamation plan from the surface owners, which is why we've moved on to 12, which encompasses both 11 and 12. 11 doesn't have a safety valve if a surface owner doesn't consent. However, 12 has that safety valve. The biggest reason that these two subsections of the statute need to be read together is Wyoming's policy for mining and making sure that that mining is happening, but also in a way that is congruent with the surface owner's rights. And when a surface owner doesn't consent to this, that's where the EQC steps in and takes a look at the mining plan, the reclamation plan, and make sure that it's balancing the rights of the surface owner as well as the rights of the applicant in order to produce these minerals. As we know, one of the cornerstones of mineral law is that the mineral owner is the dominant estate. If the mineral owner wants to go in and mine, if the mineral owner wants to go in and drill, typically they get to do that so long as they work with the surface owner. Today, you're going to hear testimony that Black Hills provided their mining plan to the DEQ, who mostly approved it except for the lack of the surface owner consent. Black Hills turned around They spoke with the Fernakes and asked for their consent, which was denied. Black Hills they reached out multiple times to the Fernakes in order to get this consent, and each time was denied. Finally, Black Hills turned to our office and requested that we move forward to retrieve an order in lieu of landowner consent. Today, you're going to hear testimony that Black Hills has provided the mining and reclamation plans to the Fernakes. Today, you will hear testimony discussing the details of the mining plan and the reclamation plan. The mining plan is detailed enough to show how the mining is going to happen, to the square footage of each of the pits, where the pits are proposed, how they dig them, how deep they do them, everything. You will also hear about the proposed routes of ingress and egress. You will hear about the reclamation plans and how those happen. The reclamation happens concurrently with the mining. As they dig the pit, they fill in the first pit, so on and so forth. They have specific seeds that they use in order to reclaim that land and make sure it returns back to where it needs to be. Today, you will also hear testimony that this mining is not going to substantially interfere with the surface use, and that Black Hills has consistently worked with surface owners to ensure that their mining doesn't interfere with the surface use. And our position is not just about mining, it is about preserving the balance that this council was designed to maintain between environmental protection and the state's economic interest and responsible resource extraction. If this council were to interpret the statute as being two separate subsections, 11, 12, and granting an absolute veto power to the landowners as the landowners would have you interpret it, it could set a precedent that invites a flood of litigation, destabilizing the balance and hindering both the mining industry and landowners alike. The decision today will have far-reaching implications. We are urging you to consider the broader impact of your ruling and to find that subsection B12 is not separate from B11, but rather encompasses it and allows for an order in lieu of landowner consent when those statutory factors are met, which will be shown today that they are. Such a ruling would honor the balance that this council was designed to uphold, ensuring that both the landowners and the mining industry can coexist in a manner that respects both the environment and the rights of surface owners granted by law. Thank you.
Thank you, Ms. Albertson. Mr. Edwards, you may proceed with your opening statement.
Thank you, Mr. Examiner, members of the council, Mitch Edwards on behalf of the landowners. We believe that today's hearing is very simple and straightforward. Looking at the statutory language that this council is here today on. The issue of the dominant estate of the mineral estate or the surface estate is really not an issue that's before this council, but it's not us, it's the Supreme Court of Wyoming that has said that by enacting these statutes that we're dealing with today, that the legislature changed the common law with respect to how the mineral estate and the dominant estate are viewed and the surface estate are viewed in terms of dominance and subservience. It was the legislature's intent to protect the surface owner, and that's set out in the statutes in numerous places. What the council's here today to decide is whether Wyoming Statute 3511-406B12 applies, because if the lands that are included in the application include lands privately owned that are covered under paragraph B11, then B12 does not apply. So the first question is whether B11 applies or does not apply. B11 provides that an instrument of consent from the resident or agricultural landowner, if different from the owner of the mineral estate, granting the applicant permission to enter and commence surface mining operation, and also approval of the applicant's mining plan and reclamation plan. If the land covered here involves an agricultural landowner, then subsection B12 does not apply. B11 provides the definition of a resident or agricultural landowner. The first part of that is whether or not the landowner holds legal or equitable title to the land surface directly or through stock holdings, such title having been acquired prior to January 1 of 1970, or having been acquired through descent, inheritance, or by gift or conveyance from a member of the immediate family of such owner. What you're going to hear and what the facts that have been stipulated to are, this is a split estate, that Black Hills, Bentonite, a general partnership, owns rights to the Bentonite, and the landowners, respondents, the Fernie cases, own the surface estate, and that they acquired that through conveyances dating back to the 1960s from Mr. Fernicus's father and brother. You're going to see that the first provision of an agricultural landowner applies. The second issue that you have to look at in the definition of agricultural landowner is whether the resident or agricultural landowner has their principal place of residence on the land, or personally conduct farming or ranching operations upon a farm or ranch unit to be affected by the surface mining operation, or receive directly a significant portion of their income from such farming or ranching operations. You're going to hear testimony, and in fact, you'll see that it's included in the mine plan, or excuse me, the reclamation plan itself, that the use of this land is for livestock grazing purposes. With that, you're going to see that the second element of an agricultural landowner applies, meaning that subsection B11 applies in this case. If this council does not find that B11 applies, then it's going to need to move on to B12. In order to issue an order in lieu of consent, the council has to find the 4 elements that are set forth. The first one is that the mining plan and reclamation plan have been submitted to the surface owner for approval. Now, the other parts of section 406B specifically provide what the mine and reclamation plan is required to provide. That is what is required to be provided to the surface owner under B12. You're going to hear testimony as to what was provided, and you're going to see that the elements that are required to be contained within a mine plan and a reclamation plan were not provided to the surface owner, while some parts of the mine plan and rec plan were provided. In short, you're going to see that the petitioner cannot meet its burden of proof under B12, even if the council were to reach that, in order for an order in lieu of consent at this time. And we are going to ask that this council deny the request and petition for an order in lieu of consent under the statutory framework and facts that you'll have before you. Thank you.
Thank you, Mr. Edwards. All right. Ms. Albertson, Mr. Tolley, and Mr. Masterson, you may call your first witness.
This is John Masterson. Mr. Hearing Examiner, can I have a 30-second sidebar with Mr. Edwards?
You may.
Thank you. Thank you. Mr. Hearing Examiner, thank you for that. And it really was a 30-second sidebar, which is unusual. What I discussed with Mr. Edwards was whether he would be okay with me showing an Onyx hunt map, just so the council is oriented geographically. So it's a demonstrative. It's on my computer with your permission. And Mr. Edwards is of course welcome to look over my shoulder. I showed him, but he's welcome to look over my shoulder or anything else. With your permission, I'd like to show that and then we'll move on.
Granted, yeah.
Mr. Examiner, I'm perfectly okay with showing a map
Okay.
so that the council has a general idea of the location of the property we're talking about.
Thank you, Mr. Edwards.
Mr. Hearing Examiner and Council, this is an Onyx hunt map. And if you're not familiar with this particular application, blue right here that I'm indicating is state property. This is federal. And then other portions not shaded are private. Here is KC, Wyoming, right here. If you can see that. And the Fernakis's property is here. I have to zoom in, excuse me, I have to zoom in. Is right there. So KC still appears at towards the upper right. The Fernakis's property is here. It's immediately to the south of a state of Wyoming parcel. And that's just zooming in a little bit. I don't know how you if there are any questions about that, but Mr. Hearing Examiner, if not, I'll proceed.
I don't have any questions.
Mr. Examiner, I'd just like to clarify one thing. That's the Fernakis property that is being affected by this application.
Thank you.
Yeah.
Thank you, Mr. Edwards.
Thank you. And I appreciate Mr. Edwards' indulgence and yours.
Are there
Thank
any
you.
questions regarding the map from the council?
Well, and I don't know who to answer, but
Mike?
red means go, right? Yeah. How large is the Fernakis holdings there? This is JD Radakovich, council member. How large are the Fernakis holdings there in Johnson County? Can I ask that question? Can somebody answer?
With your permission, Mr. Hearing Examiner.
This is Kayla Albertson. It's 314 acres.
The area affected, but I'm asking about their whole holdings in
Oh.
Johnson County. And I can wait for.
Mr. Examiner, that off the top of my head, I don't know. I just know what is being affected here. I know they own more land than what is being affected here. But the area that was just outlined is the 314 acres.
Okay, thank you.
With your permission, Mr. Hearing Examiner, we
Did you
would
have-
call Bruce Fernakis. On the Onyx map that you just showed us.
Their microphone isn't on.
Yeah, it's on.
This is Bruce Fernie Case. I'm on here.
It's not coming to this point.
Okay. This is Councilmember Lenz. The map that we were just shown of the affected 346 acres.
14.
The land is bordered by state and federal parcels. On that 346 acres that we were shown is the land between the federal and the state ground, also Fernacus property.
The land to the north is
Hold on.
Fernie Case land, but it is
Mr. Fernandez,
separate from mine.
can you hear
This
me?
is
Mr. Fernandez, hold on just a moment. Can you hear us? Okay, Mr. Masterson.
Thank you, Mr. Hearing Examiner John Masterson. I believe if it's acceptable to you, we will have testimony from Black Hills Bentonite, who does bentonite mining in this area. And it may be cleaner, if you will, if that come in an evidentiary fashion as opposed to a representation. If that's acceptable to you, sir.
It is. Thank you.
Yeah, thank you. And for the questions, yeah, we'll ask them when we have a witness. I was just asking for the map. But proceeding, Mr. Masterson, you may call your first witness.
This is John Masterson. We would call Bruce Fernacus.
yes. Go ahead.
Mr. Fernacus, there are some formalities we need to go through. Can you just hang tight just a second?
Mr. Fernandez, please raise your right hand and respond to me. Do you swear or affirm that the testimony you are about to give in this contested case is the truth, the whole truth, and nothing but the truth?
I do.
All right. You may proceed.
Mr. Fernacus, my name is John Masterson, and I'm an attorney for Black Hills Bentonite. Can you hear me okay?
Yes, I can.
All right. For the record, can you state your full name and spell it for the court reporter, please?
Yes, my name is Bruce Hill, Hill, Fernie Case, FIRNEKAS.
Thank you, sir. And you and your wife jointly own the parcel of land we're talking about here, don't you?
Yes,
And is it fair to say that you're speaking on behalf of your wife as well?
yes, it is.
All right, thank you. It's an odd situation because you are appearing by phone, which is fine. But because you're not here in person, I need to ask you a couple background questions you normally wouldn't get. Before I get to that, though, let me tell you, if I ask you a question and it does not make sense or you don't understand it, please ask me to rephrase it. Can you do that?
Yes, I can.
All right, thank you. And don't be shy. Because where are you calling in from, sir? Your home?
I am at my home in
Yeah.
Powell, Wyoming.
All right, thank you. Is there anyone else with you in the room?
No, there is not.
All right. Are you on a speakerphone or a handheld?
It's on a handheld. I can't hear the other one.
No problem. Do you have any documents or notes with you that you'll be using to help you testify?
Yes, I think I do have some that will be useful.
Okay. If you need to look at something, can you tell us and let us know what you need to look at, so we're aware of what you're doing?
Yes, I can do that.
Okay. And you understand that the oath that you took, it's applicable even though you're testifying over the phone?
I do, yes.
All right. Thank you, sir. The property that we're talking about, obviously you don't live on that land, correct?
No, I do not.
And no one lives on that property, correct?
No, they don't. No one
And
lives there.
I'm sorry, the last thing you said faded out. Can you repeat that?
No one lives there.
Are there any structures on that land at all?
No.
When was the last time you visited that property, sir?
About a year ago is the last time I was on it.
Okay. To do what?
We were down there to dedicate a memorial to my niece that we put a stone up for.
All right. Is that memorial on the property we're talking about?
No, it is not. It's out on the wall.
All right. And it's fair to say you have a lot of relatives living in that area?
Yes, several.
All right. When you visited the property a year ago, did you walk around it, drive over it, just drive through it? Tell me what you did.
Just drove through it, or drove by it more or less, just across the corner of it.
Okay. Before that, when was the time you visited it last?
I guess probably about a year before that, I was out there.
Okay. Do you recall why?
Just to take a look at the country is all.
Okay. Thank you. When did you learn about Black Hills Bentonite's interest in mining?
I have known about Black Hills Bentonite for quite a while. My father was involved long before he have been, but for the most part, I have been involved since about 2001 when I was helping my brother Chester.
Your brother Chester?
Yes, he is now deceased, but he was the owner of the property at that time.
And was Black Hills Bentonite interested in mining that property back then?
If they were, I had seen no paperwork on it then. I don't think.
Okay. Let's talk about the reason we're here today. You received, and I think we've stipulated, Mr. Edwards, that on August 24th of 2021, you got a certified mail package from Black Hills Bentonite that contained a mining plan and a reclamation plan. That's true?
Yes, that's true.
All right. You also got a form to fill out if you consented. Do you recall that as well?
Yes, it was included in that.
All right. Do you understand that the Bentonite is owned by Black Hills Bentonite?
I do, yes.
And you understand that's because of a reservation in a deed from a long time ago, correct?
Yes.
And you understand that that reservation gives them, Black Hills Bentonite, the right to access that bentonite, don't you?
Well, I'm not certain of that. It states that that is so, but I question whether they have the full right to just do as they please on the thing.
Okay, fair enough. But you'd agree that language is in the reservation?
Yes, I do.
Okay. And you'd agree that the right to remove the bentonite is in the reservation?
Yes.
And a whole bunch of other things like building roads and stockpiling soil and things like that are in that reservation. Would you agree with that?
Yes, that you're talking about this mine plan that was sent to me. Is that what you're asking about?
No, sir. I'm just asking you to agree that that Black Hills Bentonite, because of language in a deed, has the rights we've been talking about.
Well, it states yes, as reservations that these things are true.
Okay. All right. So since you mentioned it, you got a copy from Black Hills Bentonite on August 24th of 2021. Did you also receive a copy of the mining plan and the reclamation plan from the Environmental Quality Council?
No, I don't believe I did.
All right. Did you ever refuse to accept a certified mail from Black Hills Bentonite?
No.
All right. Sir, do you personally herd or brand or deliver or pick up cattle on that property?
Not usually. No, it's farther to the west.
I'm sorry, sir. I couldn't make out. I heard you say not usually, but could you repeat your answer?
No, branding and pickup delivery is not normally done. There is no holding facility on that property.
What involvement do you have with the cattle that are run on that property?
I own livestock that is managed and run by the Ferny Case Ranch. They are allowed to use this land that I own for managing and taking care of my interests.
Can you tell us what is the Furnicase Ranch?
Well, it's a ranch my father put together. He Church Furnicase was his name, and he put this outfit together, and that's the Furnicase Ranch.
And the parcel we're talking about is part of that, correct?
It is a separate parcel of land that was bought from Mitch Johnson later and deeded to my brother Chester Furnicase about a year after that.
And ultimately to you and your wife.
Yes, we now own that land.
Is that land part of what you referred to as the Furnicase Ranch?
No, it is separate. It belongs to Betty, Jean, and Bruce H. Furnicase.
All right. So as far as cattle on that particular piece of land, you own cattle that graze on that land?
Yes,
Okay. Can you tell us how many head?
I only have one cow at the time.
Okay. Can you give us some history? I mean, in a given year, how many will you run on that parcel?
Well, for the most part, I am pretty much staying out of the cattle business. I am just allowing the Furnicase Ranch to use this land that I have, and I am not planning to get back into the cattle business.
All right. Do you have any idea how many head of cattle would use that parcel of land in a given year?
Well, they are allowed to come and go from the Murphy Creek pasture, and from the school section that they have, they are able to use that land as they choose.
All right. But you're not sure how many cattle we're talking about? And it's okay if you don't know. I'm just trying to get an idea.
How many cattle would be there at any time?
Or just generally speaking.
They are they are in and out. They come down from the Murphy Creek pasture and lease land, and from they are allowed to free roam and go where they want to go.
What kind of an agreement do you have with the Furnicase Ranch to let them use that parcel for grazing?
It's verbal, and I get no lease. I require no lease, and they use that land. It's an agreement. They use that land, and they manage and take care of what livestock I have and what interests I have. They're in that land.
And what do they pay you for that right?
Nothing.
Can you tell the council, sir, if the mining operations that are before the council were to go forward, what impact that would have on you personally?
Well, with my cattle are run with their cattle, and the cattle do not approach machinery and the noises and the mining activity. They won't go down in there. It pretty well keeps them away from that land.
And you're aware that Black Hills Bentonite does mining in that area in and around cattle grazing every day, aren't you?
I am, yes, I am. But
Okay.
that doesn't mean that it doesn't affect the grazing.
I understand that. Thank you. Do you understand that under the mining plan, Black Hills Bentonite moves in small pieces across that property? In other words, at any one point in time, maybe at most 18 acres would be disturbed at the beginning. Is that your understanding?
Yes, I understand they do it in sections, yes.
Okay, thank you. You had a chance to review the mine plan. What objections do you have to it, sir?
I really don't have any objections. I am not knowledgeable about mining.
All right. You've seen the reclamation plans. Do you have any objections to the reclamation plan?
Not as they are written. It looks like that they intend to put it back just the way it was before they started.
Let me circle back to one thing, Mr. Furnicason. And I apologize if I mispronounce your name. I've heard it a whole bunch of different ways and we're all trying real hard, but so I apologize if I get it wrong.
Yeah, it's Fernie Case. It's a weird name.
It's a good name. We just have to get used to it. You've made reference to your cattle, and I need to know what you mean by that.
Well, of course, the titled cattle, you brand them. They are your cattle. They aren't payee.
Let me try to ask my question better. You said right now you have one cow. Do you anticipate getting more?
I do not. I am not going to get back in the cattle business. I don't suppose. I'm getting too old.
You're retired, Mr. Furnicase, is that correct?
I am.
May I ask what you did for a living?
I I got into well service. I worked for Dow Wells or with Schlumberger. Have you heard of them?
Oh, yes. I'm assuming then you worked for Schlumberger for, my dad was in the oil and gas business for about 50 years. So yes, I am very familiar with Schlumberger. You worked for them most of your career then?
When I started, it was Dow Chemical Company, the Dow Well division of Dow Chemical Company.
Got it. And you retired from Halliburton?
No, I've never worked for Halliburton.
All right. Or excuse me, Schlumberger. Sorry.
Yeah, that's a big mistake.
Yeah, it is. It is. But you retired from Schlumberger then?
I did.
All right. Can you tell me, sir, what are the sources of income for you and your wife right now? I'm not asking what the amounts are, but can you tell me what the sources of your income are?
Yes, I have a pension from Schlumberger, and I also receive Social Security.
All right. And the same for your wife, I assume.
Yes, that's correct.
All right. Thank you. You've had a number of interactions with Black Hills Bentonite about surface access, or excuse me, about consent. Is that correct?
I have had, we have, asked to, uh, negotiate a surface use agreement several times.
All right. Can you tell me roughly when was the first time you made that request and to whom?
Okay, I think the first time we made that, would have been I'm not real certain that I can tell you, but I think, it was with, Doug Gibson, and I think it was probably in 2021.
All right. And you were never able to negotiate a surface use agreement or an access agreement or consent, correct?
No, we never were able to, get an agreement on a surface use.
All right. Do you recall Kathy Thorson, the CEO of Black Hills Bentonite, and Mr. Madsen setting up a time and coming up to your house in Powell to talk to you?
Yes, I do.
Does July 19th of 2023 sound about right?
Yes, that's probably right. Just a second, I can probably. Yeah,
And
7/19/2023.
yeah, okay. So you were called and a meeting was set up. They came to your house, correct?
That's right.
Okay. Can you tell me about the discussion you had with them?
Well, yeah, we talked about this surface use agreement. That was their intent, was to uh, uh, obtain a surface use agreement while they were here. But I had Mitch Edwards. I had him to. He had contacted Black Hills Bentonite numerous times and been ignored. And then they wanted to come and talk to me without counsel, and I was not wanting to do that. I wanted to be able to have Mitch look at it and decide if it was right.
Did you negotiate anything or talk about anything other than the fact you wanted Mr. Edwards involved?
No, not really. They just stated what their intention was, or what they were wanting, and we sat here over a cup of coffee and talked about it. And I told them that I didn't think that any release was required. That if that they had already been in and out of that and made the road across it, and I don't know what all. So I don't know.
You kind of faded in and out on me, Mr. Furnicase, so I'm gonna try to summarize what I think you said. Did you say that you thought they already had permission to use that property?
Well, they had used the property. They had never gained permission from me to use that property or to enter it or anything. They just assumed by the deeds that they could do this, I guess, and so they just went on about their business. I didn't have anything to say about it.
But they still came and met with you to try to work out an agreement?
They did. They did finally. But after they had, there was already a road built, and they had already mined down to the south and hauled a bunch of bentonite across that property, uh, uh, with no surface use agreement or anything.
Okay, I need to break that answer down a little bit, okay?
Yeah.
You mentioned a road. That was a road built back in the 1970s or so, is that correct?
I have no idea. It was if it was built, it was just a two track road is what we're talking about back then.
Okay. Do you know what, well, let me put it this way. Since you have been an owner of that property, has Black Hills Bentonite built a road on it?
Not since I am the owner. It was prior to that. It was when my brother owned the property. I believe it would have been no. It would have been in about 19 or 2014. I can't remember.
That's okay. That's okay. But at least not while you've owned it.
I I'm not sure of that. I
Okay.
don't know.
Okay. Has Black Hills Bentonite done any mining on that parcel since you have been an owner?
No.
So when you refer to mining to the south, you're talking about someone else's property.
That's right. Yeah, it's south of my property.
All right. I just wanted to be clear, sir. So help me understand then, given all that you've said, why not sign a consent or reach an agreement with Black Hills Bentonite?
I was always
Hold on.
Objection, compound, and speculation.
I will rephrase the question, Mr. Hearing Examiner. I'll break it up a little bit. Why, given everything that you've said, would you not sign a consent for Black Hills Bentonite?
because I wanted a formal surface use agreement, and I wanted some compensation or some agreement to make it worthwhile for me.
Did you ever see a formal written surface use agreement?
No, I haven't. I've never really seen anything, but I know that there are surface use agreements put together.
Do you recall during his visit to your house, Mr. Madsen telling you that he'd rather pay you than lawyers to go through this process?
I do. Yes, I do.
Okay. What was your response to that?
I don't know that I had a response. I felt like that we needed to do whatever necessary to get a agreement on the use of this land, surface use of this land.
Proposed any terms for a surface use agreement, sir?
Say that again.
Have you ever suggested the terms that you would accept in a surface use agreement?
We have never got that far. No.
Okay. Do you believe you have a right to deny Black Hills Bentonite consent?
I do.
Objection calls for a legal conclusion.
I don't believe it's a legal conclusion. I'm asking for his belief, Mr. Hearing Examiner.
I'll allow that.
Can you tell us, what do you base that conclusion on?
Well, I think that when you own land, that you should be able to uh, control what goes on that land.
When you got your interest in this parcel, the deeds at the bottom, they all say something to the effect of subject to easements and reservations of record. Do you recall that?
Yes, I do.
When you acquired your interest, were you aware of these reservations?
I had not seen the earlier deeds. Some of the very early deeds laid out an awful lot of this stuff that I didn't know about.
All right. You know that that was filed with the Johnson County Clerk?
I'm certain it was, yes.
And would you agree then that when you acquired your interest, it was subject to all those rights?
Yes, but I was unaware of all of these reservations until Mitch Daniels or Edwards went and researched these deeds there in the courthouse for me.
Fair enough. May I have just a moment and I'll confer with my co-counsel. I don't know if I have much more, Mr. Hearing Examiner. Mr. Fernicase, this is John Masterson. I appreciate your patience. I just wanted to check with my co-counsel about, make sure I didn't forget anything. I need to make one correction. I think I said Kathy Thorson. It's Cindy Thorson. My apologies.
Yes,
And
yes, Cindy was here. Cindy was here with Larry that day for that
Right.
meeting. Yes.
Okay. That's all I have of you right now, Mr. Fernicase. I appreciate your time. Thank you.
Okay.
Thank you, Mr. Masterson. Mr. Edwards will move into cross-examination.
Thank you, Mr. Examiner, members of the council. Mitch Edwards, Mr. Fernicus, I just have a couple questions to clarify some things that you said, testified to here today. Just so the record's clear, your father's name was Church Fernicus, is that correct?
Church Hill Fernicase, yes.
Okay. And we have deeds here that show he received a deed for the property we're talking about in 1962. Does that purport with your recollection of when your father acquired this property?
Yes, 19 he bought that property from Mitch and Gene Johnson in 1962.
And what did your father use the property for during his ownership?
Uh, he used the same thing it's being used for now to graze livestock. It is agricultural land that is used for grazing livestock.
And on one of the deeds, we see another individual referenced as Maggie Fernicase. Who is Maggie Fernicase?
That is my mother.
And then we have a deed in the record dated 1967 from Church Fernicase and Maggie Fernicase to Chester Fernicase. Who is Chester Fernicase?
He is my oldest brother. He is now dead.
Okay. And when he acquired the property, what did he use the land for?
It's same thing that it's being used for now. He had cattle that were run on the Fernicase Ranch, and yeah, same thing we're doing now.
Okay. And then Chester Fernicase, we have a deed conveyed it to you and him in 2001. Is that your recollection of when you first gained a title ownership in this particular property?
Yes, it is. Yeah, he got to needing some money.
And we talked a little bit with Mr. Masterson, asked you some questions about a surface use agreement. Did Black Hills ever propose to you a surface use agreement?
No, no.
Okay. What was it that they asked you to sign? Was it just the consent form?
Yes.
I have no further questions. Thank you.
Thank you, Mr. Edwards. Does the council have any questions for this witness?
Just have a quick question so I can.
Announce yourself.
Marjorie Bedessum, council member. I just have a quick question so I understand the relationship between all these properties. So Bruce, you had said that your father, Church, started the Fernicase Ranch. And
yes.
That's correct. And at this point in time, who owns the Fernicase Ranch? Do you have any financial interest in that ranch? Who owns the Fernicase Ranch?
I don't have any interest in the Fernicase Ranch itself. It is owned by Boone and Dale, father and son, are the owners now.
And how are they related to you?
Dale is my nephew, and Boone is his son, which would be, I guess, great nephew, huh?
Okay, all right. Thank you very much.
Thank you, Councilmember Bedessum. Any other questions for this witness from the council? Seeing none, any redirect, Mr. Masterson?
No, thank you.
No redirect. Okay. Thank you. Let's see. Mr. Fernicase, at this time, I don't know if it's proper down. I'm not sure if that's the proper thing, but you may step down. And at this time, I'd like to take a quick recess, if we could, if that's okay with everybody, just a 5 or 10 minute recess. Yes.
Mr. Green.
Mr. Edwards.
Thank you. Just to ask one question with regard to Mr. Fernicase. Is he free to leave the phone conversation if he so chooses to? Obviously, he's free to stay on and listen, but is he free to leave if he needs to leave?
He is, yes.
Thank you.
Well, any objection to that, Mr. Master?
This is John Masterson. Thank you, Mr. Hearing Examiner. I have no objection. I guess, but my request would be, should something unforeseen pop up, perhaps Mr. Fernandez could be available if we needed to bring him back in some eventuality. But as far as staying on the phone, no objection at all.
Okay.
Is that acceptable?
Yeah, Mr. Examiner, we have his phone number. If we need to try to call him and get back in touch with him, that's fine. I
Okay.
just don't know if he wants to
Yeah, and I think that's
sit
fair
and
enough.
listen through
Yeah.
everything. So
Understood. Thank you. Okay, well then, with that, I think we will take I need to make a motion. Or do we need a motion? Okay, we'll take a 10-minute recess and be back at 11:11 a.m.
I'm actually other than that, I'm fine.
I graduated in 2021. Yeah, everything. That's important to know. Oh, yeah, actually, because yeah. Okay, but really, are you? Yeah. Okay. Yes. Yeah. She did some. And then you
They like himself.
Okay.
We have a light. Thank you.
Okay, it is 11:14 a.m. and we are going back on the record. Looks like everybody is here and present. So, Mr. Masterson, go ahead and call your next witness.
Mr. Hearing Examiner, Ms. Albertson will be handling the next witness. I wanted to give you a quick status. We have two more witnesses and we will be concluded. Doug Gibson and then Mr. Madsen. And you never know about these things, but I don't think they're going to be particularly lengthy. I'm aware that the council aims for lunch from 12 to 1. We may want to see where we are, because maybe if you go a little bit later, we might be able to conclude. And I can't, obviously, I won't speak for Mr. Edwards, but just a report.
Yes, thank you for that. All right. Ms. Albertson, you may proceed and call your next witness.
Thank you. I'd like to call Doug Gibson, please.
Yeah, you can sit. See, make sure the mic's on. Yeah. Mr. Gibson, please raise your right hand and respond to me. Do you swear or affirm that the testimony you are about to give in this contested case is the truth, the whole truth, and nothing but the truth?
I do.
Okay. And can you state your name for the record?
My name is Doug Gibson.
All right. Thank you.
And would you mind spelling your name too, just to make sure it's correct?
First name D-O-U-G, Gibson, G-I-B-S-O-N.
Perfect. Thank you. So Doug, who are you in relation to Black Hills Bentonite?
So I guess you could call me, my current position, I guess, is like a permit supervisor. So I put together permit applications. If we do any mine plan revisions, I do that. I go out into the field. I kind of monitor things as mining is progressing. I do odd things, you know, in between. If I have to do weed spraying, I do weed spraying. At the very end, when you know, our mining features have been reclaimed, and if there's topsoil involved, I'm usually the one that goes out and seeds it. And then also I deal with the state regulators and go out with them on annual inspections when they come out to see how mining has gone for the year.
And how long have you worked for Black Hills?
I've worked for Black Hills Bentonite now 15 years.
And how long have you been in your current position?
So my current position, I came into place in it at the end of 2019, going into 2020.
So part of your job duties is creating, reviewing the mining plans and reclamation plans. What do those include?
So the mine plan kind of, for most of them, they're pretty general. You know, they include like a little bit of history, like, you know, the type of bentonite bed we're going to mine, the equipment we're going to use, the kind of general procedures that we're going to do when we go to mine an area. Like if we start a pit sequence, it'll kind of give a general idea on how that pit sequence will progress and how we'll take topsoil and we'll pilot in locations in the area, and then we'll create an overburn stockpile area where we take the overburn out of the first pit, put it in a pile, and then usually we'll use that area to, when we get to the bentonite, we'll pull the bentonite and we'll place it on that overburn stockpile until it gets hauled off. And then it'll tell about, when we go to do the next pit, then that overburn will go into the first pit, and so on and so on. And then if there's any wildlife things that we got to take into account, sometimes like these days in the area, there's sage grouse issues. So we'll say, we'll put in that mine plan if it's required. We're not going to disturb topsoil during March through June, or we're not going to make noise from 8 p.m. to 6 a.m., with our mining activity and so forth. And then the rec plan kind of gives a general description of when we're done, how we're going to reclaim the area, the seed mix that we're going to use for the area. And then it talks a little bit how at a certain point we'll try to get bond release from the state if the reclamation is as good or better than how we found it. Then we'll apply for bond release, and the state will come out, look at things, and if it's good, they'll approve it, and we'll basically be done with it at that point.
So approximately how many mine plans and reclamation plans do you do over the course of a year?
It varies. Typically, I might put together one complete permit application, which, if we're going into a new area that's not currently in our permit, then I'll put a total permit application together with all the baseline surveys, a new mine plan, rec plan, and then submit that to the state. Also during any given year, I might do 2 or 3 mine plan revisions where it's like if we already have an approved permit area, if our mine plan needs altered, or we're adding some stuff into that approved permit, some new mining, then I'll put those together. Those aren't as labor intensive. They usually take a couple of months or so to put together and submit.
So after you have created the mine plans and rec plans, you submit them to the state. Generally, what does that process kind of look like?
So once everything's together, I'll submit it to my permit coordinator, which for Johnson County is he's out of District 3 in Sheridan. So I'll submit that to him, and then he'll review it for completeness. If he has any questions on things, then he'll give me some review comments, and then I'll address those issues. If I have to change documents, I'll change them and then send them to him. And it kind of goes back and forth for a little bit until the state is satisfied with what we've proposed or plan to do. And then once they are, then they'll send out to us an approval letter.
So kind of switching gears, the permit to mine 248C, was this an original mine plan, or was this one of the amended ones?
So this area that we're dealing with in Murphy Creek and with Mr. Furnicase, that area was part of our original permit. When the permit was issued back in the 70s, Black Hills Bentonite basically told the state, this is the area that we want for our permit. And it was primarily based on patented deeds that Black Hills owned, or lease agreements at the time, or, deeds where, wherever they had the right to mine at the time, that's what they pretty much proposed for their permit. So Black Hills got issued that permit. And within that original permit, that conversion permit, whenever going forward they wanted to do mining, they would have to submit a Chapter 13 update application, which basically provided the baseline surveys for that area, veg, soils, and wildlife, sometimes wetlands. and a mine plan and reclamation plan. And so this area, that's why it's called the Murphy Creek Update Area, because that's what we did for that area. And I believe that Murphy Creek original update application was approved around 2011, I believe is when that was approved.
Was there anything different or unique about the 248C updated mining and reclamation plans?
Anything unique about it? No, not to my knowledge.
So the mining and reclamation plans for this specific land, does that include the proposed hauling routes for the mining?
You mean like when we're going to haul the bentonite out that we've mined?
Yes.
Sort of. So currently there's a main access road that goes through that whole Murphy Creek update area. It goes completely through from the north end of it all the way to the south end of it. So
yeah,
all our proposed mining features that were currently submitted with this mine plan revision that we did, which is you could see on that map up there. So or on that exhibit over there. So there's a main access road that cuts all the way through there. And then all our mining, which you could see on either side of that access road, is in the colors of red, yellow, blue, maybe orange. So all those they all branch off of that main access road. So sometimes we'll have like a small access road off of that to get to the specific mining sequences and whatnot. And they should all be shown on that exhibit.
Okay. I'm sorry, Council. I recognize we have not produced this on our online filings. We were planning to produce this as for demonstrative purposes and potentially move to admit this after Doug has testified to what this is, where it came from, how it was made, laying that foundation.
Okay. I am not sure that we have a visual from our online that they can see that. Can we move it to where we have visual? We might have to put it in, in this back corner or something, just so Councilman True can see.
Yeah.
We may have an electronic.
Okay, yeah. Thank you.
And excuse me, I'm sorry, Mr. Hearing Examiner. Mr. Edwards and I had talked about using this as a demonstrative, so I don't think there's a problem with that use. Mr. Gibson can give whatever foundation, and we'll see where that goes. We're trying to find the PDF. We had to have it sent out because it's so big to get it scanned.
No, understood. I just want to make sure that our chairman can see it online.
Yes, understood. Thank you.
Mr. Hearing Officer,
Yes.
can I ask a question?
Yes, Council Member Lynch.
Ms. Albertson, would you mind taking a moment and having Mr. Gibbons stand beside it and trace the main road through the Murphy Creek area and then point out the parcel in question?
Perfect. Can do. Doug, would you mind pointing out the main road?
Okay, just for reference, so this is another main access road that comes in off of this portion of the map. And we call this.
He can't be heard, I'm sorry.
Maybe this one.
Sorry, this will work good. Sorry. Okay, so off here to the right, this is like another main access road of ours that, comes from a county road. And we call this, like, for us, it's the Murphy Creek Road. So this comes into our mining, and then there's a road that breaks off and it winds through here. comes all the way down. Right here is where Mr. Furnicase's land starts. Up here is a state lease area. So the road comes through Mr. Furnicase's land here and continues all the way down through Mr. Furnicase's land, and then goes on to land owned by the 3T Ranch Company, and it continues south.
Thank you.
Thank you, Councilmember Lenz. All right, Ms. Albertson, you may proceed.
Thank you. As part of the 248C mining plan, does that include, as you were discussing earlier, the full plan of how that mining is going to occur in these areas?
For the most part, at least like what has been, submitted to the state so far, is what you see on the map. In the future, mining progresses all the way south of there. It hasn't been proposed to the state yet, but there is mining that goes way south of there. Even on Mr. Furnicase's lands, which on this particular map, because it hadn't proposed it to the state at the time, there is lots of areas within there that could be mined as well. But like I said, it's not shown on this particular exhibit.
And for the reclamation plan for 248C, does that fully lay out the plans for the reclamation for this proposed mine area?
Yes, yes.
When you submitted this mining and reclamation plan for your application to this state, what happened after that?
Immediately after that, the state came back and they asked that I do additional veg and wildlife surveys because so this is like going on in 2021, and the original studies were done, starting in like 2004, that time frame. So for the vegetation and wildlife, the state said, this is those surveys are basically outdated. They're greater than 5 years old. So we'd like you to, update them. So then I contacted our contractor that does veg and wildlife studies for us, and asked him to redo those surveys for the update area to bring everything more current. And then at the time, because they wanted those, I asked the state if they would be okay if I submitted like a smaller mine plan revision that would just include a couple of pits within the state lease area, if they would be okay if I did that and get approval on that, just so that we could keep mining and not hold up our operation until the surveys got completed, and then I could get approval of the whole thing. And they were okay with that.
So following the studies and everything, and you did a revision of the plan to include the updated studies and sent that back to the state. What happened after that?
So once I had done all that, we did a little bit more back and forth with review comments. I think we did like 2 back and forths. They gave me 2 rounds of comments, and I altered things or made changes based on their comments and submitted them back. And eventually they were satisfied with everything that I had proposed to them, and they approved of like this mine plan revision. So we received an approval letter from the Land Quality Division like July 18th of this year.
At what point did the state require you to get surface owner consent from the Furnacases?
So prior to submitting this initial mine plan revision, which was back in 2021, we had phone conversations back and forth. And just during those conversations, the state said, or the permit coordinator at the time said, you're going to need to get Form 8's surface owner consent when you do this mine plan revision. So besides Mr. Furnicase, the state's obviously involved. And then there's another private landowner involved, and his area would be in the northwest corner of that area. And so I submitted a mine and rec plan and Form 8 to both the state through the OSLI, and then I sent one to the other private landowner, and then I also sent one to Mr. and Miss Furnicase.
And what happened after you sent that to Mr. and Mrs. Furnicase?
So I don't know exactly if it was myself that called Mr. Furnicase or if he had contacted me. I don't remember who reached out to who first, but we had an initial conversation, and it was basically, I was asking him if he wanted to try and set up a meeting where he could talk with upper management, and if he had any concerns or things like that, then, he could discuss it with them and see what he wanted to do, or basically talk with them, and they could come up with whatever, an understanding of going forward or whatever it would need to sign off on that Form 8.
And just to make sure that this was covered, when you sent the Form 8 to Mr. and Mrs. Furnicase, did you also send the mining plan and the reclamation plan with that?
Yes, it should have been all in one binder. Usually when I send that stuff out to anybody, I put it in a 3-ring binder and it's all together.
Okay. So during your conversation with Mr. Furnicase, you guys were trying to come to an agreement for him to sign the consent.
I don't know if him and I were, the conversation between him and I weren't to discuss that, because that's really not my, where I'm not authorized to do that. I'm more of like an intermediary. So it's like, if the company wants to reach out to certain landowners, I'm usually the one that is in between trying to set stuff up. So I'm not authorized to say, hey, we can do this for you, or we can do that. I'm basically just, hey, trying to bring people together, or, try and schedule things. So during that conversation, just trying to lay things out, and I don't remember everything verbatim, but, Mr. Furnicase did mention about, how his family used the land for grazing, and, that type of stuff was his main concern. During the conversation, he asked me, like, should I get an attorney? And I told him, I said, Mr. Furnicase, I'm not in a position to tell you what to do on that one way or the other. I said, personally, or my personal opinion, I'm like, you should do what you feel comfortable with, or what makes you feel comfortable. But, I know the company's willing to try and meet with you and stuff, but outside that, I can't tell you what you should do. You got to do what makes you feel good about things. And that was pretty much just the extent of our conversation.
And after that, did you have any further conversations with Mr. Furnicase?
I did, but it was like sometime after our conversation, like I had seen a cover letter, and I think it was from Mr. Edwards, where it, so it basically indicated that Mr. Furnicase was working with an attorney. So from that point on, I didn't personally reach out to Mr. Furnicase on my own. When I did, which was, there was two phone calls that I was part of involving Mr. Furnicase, because I didn't want to do anything if like the attorneys for Black Hills and Bentonite didn't instruct me to, or if upper management didn't ask me to. So in July of 2023, management asked me if I could reach out to Mr. Furnicase and try and set up a meeting to where they could discuss things with him. So I called Mr. Furnicase, and through that, I was able to set up a meeting for July where Mr. Matson and Ms. Klimstra would go out to Powell and meet up with Mr. Furnicase and his wife. So that was that conversation. And then I was part of another phone conversation with Mr. Furnicase where Mr. Matson and myself, we were in the conference room and we kind of had a conference call with Mr. Furnicase. And because I had gone to Larry and I had said, you know, because of all the deeds and the deed language where it really said that, you know, Black Hills Bentonite had the right to the mineral and had the right to, you know, disturb whatever land they wanted or whatnot, you know, at least to me, it was like, well, Mr. Furnicase, we didn't really have to, Black Hills Bentonite didn't have to provide compensation for that. But before going to the EQC, I reached out to Mr. Matson and I was like, well, maybe we should just give Mr. Furnicase another call, and maybe instead of paying money to get attorneys involved and go further, then maybe we could just give that money to Mr. Furnicase in order to get the Form 8 signed. So we had that conversation with Mr. Furnicase and proposed that idea to him in that conversation. And that was the last conversation that I was ever a part of with Mr. Furnicase.
Okay. As far as you know, besides the testimony you heard today, did Mr. Furnicase have any objections or concerns with the mining and reclamation plan you provided?
In the conversations that I've had with Mr. Furnicase, no. I mean, he never, you know, never indicated that he had any issue with what specifically the mine plan showed or whatever. No, I never heard any issues or, you know.
Okay. Kind of switching gears. So have you ever physically visited this mining area, both the state of Wyoming lease or the Furnicase land?
Yes, I have been through both areas. Yes.
Okay. Generally, what is the landscape up there?
So the landscape, you know, it's your typical sagebrush shrubland looking area. There are a lot of bentonite outcrops in the area, and a lot of shale outcrop. Well, not a lot. Towards the east side of the property, there's a lot of shale ground, shale outcrops, bentonite outcrops. There's not a lot of great vegetation on there on those spots, but there is like sagebrush shrubland through there, you know, grassy vegetated areas through there. It's kind of a mix of all types.
And typically, what is this land used for?
To my knowledge, it's I've only seen like grazing out there, you know, I've seen cows out through there, and then, you know, the wildlife in the area, which is typically the pronghorn antelope and, you know, mule deer from time to time you'll see.
Do you know whose cattle specifically is kind of grazing out here? Who they belong to?
No, I do not. I mean, you know, the 3T Ranch has land to the east, has land, primarily to the east. They have, and then they have land to the southwest. So there are 3T livestock grazing throughout that whole area adjacent to the state and Mr. Furnicase's land. The livestock that I've seen on the state lease area in the past years or through Mr. Furnicase's land, I don't know who owns them.
So for the lands that you've mined generally in this area, for the owners of livestock, how do you work with them so it doesn't impact that grazing?
For the most part in this area, there are like to the north where we've mined, which is an area called Peterson Draw, or we call it Peterson Draw. To the north, there's a landowner or family partnership, Harlan's. So for them, throughout the years when we've mined through that area, they've had like, during lambing season for like 2 months, 2.5 months out of the year, in part of our agreement, they asked like, hey, nobody's to be in here. So for those 2.5 months out of the year, we don't do any mining in their land. We don't do any hauling. If we got to go in there, usually it's like if I had to go in there to look at an area or check something out, I can do that, but I have to get permission from the ranch to do that. Otherwise, we are to stay out of there. So we do. Other landowners in the area, there hasn't been any grazing issues like brought to our attention. In different permit sites that we work with and the landowners I deal with, if they're concerned about grazing, we'll have discussions and they'll say, hey, can you alter this a little bit? Or can you not do this till then? Then I do everything I can to work with them so that, everybody's okay with what's going on.
Perfect.
Okay, just a couple more questions.
Sure.
So kind of going back to the current mining plan at issue in this matter. When you say that there's nothing unusual about this one, there's nothing that stands out comparative to other mining plans.
Mhm.
Okay.
That is correct. There's nothing different than what I've done or Black Hills Bentonite in the past has done for other areas that we mine in. Yeah.
Okay.
Correct.
And then also looking at the mining plan, there's a specific line in here that says whereby a sequence of excavated areas or pits, typically less than 5 acres inside, are developed to expose and remove the underlying bentonite deposit. Can you explain that in layman's terms?
Could you repeat that one more time?
Yeah.
I get the gist of what you're asking me, but if you would repeat that one more time, that'd be great.
Yeah. So a sequence of small excavated areas or pits, typically less than 5 acres in size, are developed to expose and remove the underlying bentonite deposit.
Okay. I'm going to stand up just to
Perfect.
illustrate. So what that's all referring to is just basically, it's just describing a pit sequence. So for this map over here, anything that you see in red, those are proposed pits. So that sentence is basically just describing, we're talking about a sequence of pits and it's describing what we're going to do in relation to those pits. So basically say, take this area here. What it's describing is, okay, we establish these sequence of pits. So when we go into our first pit, we're going to remove the topsoil and plant it in, or put it in areas designated for topsoil stockpiling, which on the map would be areas in blue. So we'll pile the topsoil, then we'll remove the overburden, and we'll usually pile it on the overburden stockpile area, which would be these areas that are in yellow. Once we take the overburden out of that first pit, once we'll get down to the bentonite, which is typically about 30 to 50 feet in depth. So once we get down to that bentonite, we'll take it out of the pit and we'll pile it on that overburned pile base. And then we'll just proceed on down to the next pit. And it's just a general description of how we mine.
Sorry, I have nothing further for you, but I'm sure Mr. Edwards does. Thank you.
Thank you, Ms. Albertson. Mr. Edwards, witness is yours for cross-examination.
Thank you, Mr. Examiner. I'm happy to proceed now. I know to noon. It's going to take me longer than 10 minutes, so I don't know if you want me to proceed and then break in the middle, or if you
What
want.
do you think as far as the time? Do you have any?
I don't know, because I don't know how exactly the witness is going to answer, but probably 20 minutes.
Yeah. Okay. Yeah, let's go ahead and proceed. Yeah. And we'll ask questions. We'll let him. Yeah. Yeah.
Thank you, Mr. Examiner, members of the council. Mitch Edwards on behalf of the landowner respondents. Good morning, Mr. Gibson.
Good morning.
I have some questions for you to start out with regarding your testimony on the back and forth process with the DEQ in revising your submissions. Did that include revisions to the mine plan and reclamation plan?
So it did involve revisions to the mine plan. So if nothing changed in terms of like what you see on the map, nothing changed like that. What did change in the mine plan is like the copy of the mine plan that the Mr. and Miss Furnacase got was originally 22 pages in length. After doing the back and forth with the DEQ and making changes, the end result was the mine plan was only 17 pages in length. And the reason why it became only 17 pages is because in a lot of our mine plans, we would describe like each pit, we'd give a little description on each pit, like topsoil from this pit is going into this top, overburn from this pit is going to this overburn stockpile, and so forth. So it's just a sequence going, just saying dirt from this pit's going here, dirt from this pit's going here. And basically the DEQ said, we don't need that information. So I removed that information from there because it wasn't necessary. So nothing in terms of like how we mined or how all that would proceed. None of that stuff changed. Just those specifics on how dirt would be placed here or there or whatnot, that was removed. And then so that was removed. And then there was one thing that was added, which was at the very end where the DEQ wanted me to place in the mine plan specifics regarding sage grouse. So they wanted me to have sentences in there that said, we will not be disturbing topsoil during breeding and nesting season, which is from like March to June. And then they also wanted me to put a sentence in there saying that we're not going to have any noise, from 8 p.m. to 6 a.m. So those two sentences were added at the very end of the mine plan, and that other language was just taken out. But everything regarding the mine plan stayed the same in the text document, and the map, nothing changed on the map.
And with respect to the revisions that you made, am I understanding you correct that those revisions that Black Hills Bentonite never sent those to the Furnacases?
That is correct. Mr. and Miss Furnacase did not get a revised copy of that mine plan, at least from me. You know, because like I said, once lawyers are involved, I don't do anything without being instructed. So, and oh, sorry, with in terms of the reclamation plan, nothing changed regarding the rec plan.
Mr. Gibson, you testified that you had sent the mine plan and reclamation plan as it was originally proposed to the Fernie cases. Is that correct?
That's correct.
And did you do that by cover letter?
That would be correct.
Okay. On the table in front of you is a black binder that's your company's exhibits. If you turn over to Exhibit H, and these exhibits have already been stipulated to as admissibility. If you take a look at Exhibit H, is this the cover letter that you sent to Fernie cases, introducing yourself and providing them with a copy of the mine plan and reclamation plan?
It is the letter, yes.
Okay. And in the letter, well, this letter is dated August 24th, 2021, correct?
Correct.
Okay. And the revisions that you were talking about that occurred to the mine plan occurred after this letter was sent?
Yes, this, in fact, it would have been like this summer is when those took place.
And if you look down in this letter, it would be the third paragraph where it begins, please review the enclosed mine plan and reclamation plan. You see that?
I do.
And with that, you sent them a copy of the mine plan and reclamation plan.
Correct.
Okay. And you testified earlier that you did that typically in a binder form?
Correct.
Okay. I'm holding up a binder form. Does this look familiar to you?
Yes.
Is this binder what you would have sent to Fernie cases?
Correct. Yes.
Okay. May I approach the witness?
You may.
Okay.
Excuse me. May we see that? We have not seen this before.
Sure. I think you have some innocent.
Oh,
Yeah.
We have no objections, thanks.
Mr. Gibson, I just wanted you to look through that and
sure,
and tell me, is that what you sent to the Fernie cases?
Yes, although it should have a map in here, or, you know, because like I said, the mine plan document, it's usually like general, you know, it never really changes, you know, mostly the differences between landowners and or different spots, you know, is like what you see on the map. So there should have been a map in here. And for this application, there is a reclamation plan map. And so that should be in here as well. Or, you know, usually when I send stuff out to people, you know, it'll have the mine plan and maps that are associated with it. I mean, because the map's like the most important part.
And Mr. Gibson, do you know why there's not a mine plan map or a reclamation plan maps or any maps in what was sent?
No, I mean, because it's highly unlikely that I would forget to put them in there. And because like I said, I sent this out to like 2 other, you know, I sent a copy out to the state and I sent a copy out to another private landowner. So I can't explain why it's not in there. Is it a possibility that I forgot to include them? Anything's possible. But I mean, this is like started like 3 years ago. So if there's something that wasn't in there, it could have easily been rectified if I'd have known it wasn't in there.
If you wouldn't mind,
Sure.
in the white binder that's in front of you is plaintiff's exhibits, which have been stipulated to. If you take a look at,
Ooh, 1 sec, or am I done with these two or?
for now, yes.
Okay. Okay.
All right. If you look at exhibit 3,
Okay.
does that appear to be the mine plan that you sent to Fernic cases from the binder that we were just talking about earlier?
I apologize. I don't have my glasses. So if it looks like I'm taking a long time, it's.
And I'll represent to you, sir, that we didn't change any of the
Oh.
contents of any of the pages,
Gotcha.
but I just want you to kind of know, or let me know if that appears to be the same.
Yes.
Okay. And then if you look at exhibit number 4 in that white binder.
Okay. Yeah. The rec plan.
The
Yes.
rec
It does
plan.
look to be the same too. Yes.
Okay. Thank you. Now, just so we're clear, that's the mine plan prior to any revisions.
That's correct.
Okay. Now, if we go back to the black binder to exhibit H, in the exhibit H,
Exhibit H.
which is your letter of August 24th, 2021.
Yes.
Okay. If you look at the 4th paragraph of that, you state there, also to my knowledge, there is currently no surface use agreement between you and Black Hills Bentonite for this area that would provide compensation for each acre that BH disturb. At your earliest convenience, please contact me so that BHB can begin discussing with you terms of a potential surface use agreement. Is that what you sent to the Fernic cases?
That is correct.
Okay. And with that, did you send any proposed surface use agreement?
No. And am I able to explain a little bit on that letter?
Yes, sir.
Okay. So before I even sent this letter out, I had gone to Mr. Mattson and asked him like if he knew of any types of agreements that we had with Mr. Fernic case. And, he had mentioned that he didn't know of anything. And the reason why I'd asked because on that one road that I described, other main access road, the Murphy Creek access road, when we had initially proposed that road, there had been, or at least I had come across some documents that looked like we had contact with Fernic cases, because when we initially proposed that road, it was proposed to go through a part of Mr. and Mrs. Fernic case lands that were along that road. At the end result, though, when that road was built, it went around Mr. and Mrs. Fernic case property. So that's when I was looking through for any agreements between Black Hills Bentonite and Mr. and Mrs. Fernic case. I had come across that. So that's why I went to Mr. Mattson and knew if he knew of anything for the Murphy, for this stuff that we were proposing. And he didn't. So then that's when I, wrote the letter, put together the minor rec plan, and then sent it out to Mr. and Ms. Furnicase. And on that fourth paragraph that you did mention where it talked about discussing terms of potential surface use agreement. So I put potential in there on purpose because I didn't know, you know, all the rights and whatnot that Black Hills Bentonite had for that area at the time, because, you know, I don't really handle lease agreements or just stuff between landowners. So I didn't know what existed at the time. So that's why that language was put in there, in that letter, because I didn't know what would be okay or not okay, or what right anybody had, because at the time wasn't in my area, I guess you could say.
Thank you for that explanation. You testified earlier that you work with landowners in respect to their grazing operations.
Correct.
Okay. And you used a specific example of the Harlans, I believe you
Yes.
said.
Correct.
Is that in the Murphy Creek permit area under the 248C permit?
No, in reference to the map, it is way north of there, probably 2 or 3 miles, maybe north of that.
Okay. And in regard to what you were testifying about with regard to seasonal operations to avoid interference, if you will, with the livestock operations, do you know whether that's in the mine plan?
It is not in the mine plan. It's based off a separate agreement between Black Hills Bentonite and the Harlan family at the time when that document was developed.
Is that separate document with the Harlans a surface use agreement?
I don't know. It's not. I don't think it's part of like a separate surface use agreement. It's part of like an overall lease agreement with the family and Black Hills Bend. I think Mr. Matson could explain that better than I could.
Okay. But it's not included in the mine plan or reclamation
No,
plan?
it's not listed in the mine plan or rec plan, no.
Okay, you talked about the 3T ranch. Do you have operations under the 248C permit on the 3T?
Yes, we do.
Okay. And do you work with them with respect to their concerns regarding grazing livestock?
With respect to the 3T, we don't really, or they've never, with respect to grazing, I don't know of any specific restrictions or any issues that the 3T has with what Black Hills Bentonite does. I mean, the 3T ranch is like tens of thousands of acres. So what we do on them is pretty insignificant compared to their overall operation. In the past, like usually like when I deal with representatives of the 3T ranch, it's usually with the general managers or the ranch foreman. Those are the people that I deal with on the 3T. In the past, there's been like a concern about the 3T with Murphy Creek access road that I pointed out on that map. We do a lot of hauling. So that road tends to get dusty over time. So like a concern that the 3T ranch had was they were concerned about all the dust because the dust gets on the adjacent vegetation. So then the cows, you know, nobody likes to eat dirt. So after finding about that concern from the 3T, I acquired permits in order to I got water use permits from the state so that I could get water for haul trucks from several points in this area. So now when we're hauling out there, we have a water truck. So the water truck keeps for dust control. That's the only concern that I know of that the 3T has ever had.
Do you know, sir, whether or not you have a separate agreement? Black Hills Bentonite has a separate agreement with 3T regarding surface use and these types of things?
Not to my knowledge, because most of the stuff that we do on the 3T was with patents. You know, Black Hills Bentonite got the patented mineral rights for most of the area that's on or deals with the 3T. We have done some mining on BLM lands and state lands that are adjacent to the 3T ranch, and that maybe, you know, the 3T has grazing leases on those areas. To my knowledge, I don't know of a specific surface use agreement with the 3T.
And then with respect to the state section, do you know if Black Hills Bentonite has a surface use agreement with the grazing lessee or the state?
So when we initially went in there, there was no active grazing leasee on that land. If my memory's correct, and I'm not positive, I believe years before, I believe the Furnacase family did have the grazing lease with the state for that area, but then it got dropped or maybe forgotten, because when we first went in there, I had to come up with a grazing impact agreement with the state. So for the few or the acres that I did get approved of to disturb from the state, I had to deal with OSLI and make payments to them for our disturbances there. In the end of 2023 or into the early part of 2024, OSLI did contact me and say that someone did pick up that current grazing lease, and it was Dale and Boone Furnacase, Mr. Furnacase's relatives, who did acquire the rights to graze on that area. And then this summer, or beginning of summer, I did reach out to Dale and talk to him about how, you know, him and Black Hills Bentonite would need to come up with an arrangement or an agreement since he was the grazing leasee. So I talked with Dale, and I told him, like, for other landowners in the area, and even when I dealt with the state for this particular section, that the state and other landowners had agreed to an amount of like $125 per acre for, you know, areas that we disturbed. So Dale asked if he could think about it for a while, and then we, you know, talk about it later. And I said, you know, that was fine. You know, towards the end of summer, beginning of fall, and try and, you know, work something out. That would be great, because come the first of the year, I would have to, you know, make payments or whatever.
And you had those discussions with Dale Furnacase?
Yes,
okay.
yes.
You haven't had those discussions, though, when it comes to Bruce and Betty Jean Furnacase's land with Bruce and Betty Jean Furnacase. Is that correct?
No, I haven't had no. Outside those conversations that I mentioned, I haven't talked with them. No.
Okay. One of the things that the statute provides that the mine plans to include, and this is at B 13, it says the procedures proposed to avoid constituting a public nuisance, endangering the public safety, human or animal life, property, wildlife, and plant life in or adjacent to the permit area, including a program of fencing all stockpiles, roadways, pits, and refuse or waste areas to protect the surface owner's ongoing operations. I just, yeah, absolutely.
With your permission, Mr. Hearing Examiner,
What's the
just
question?
give the witness a copy of the statute that
Yeah.
I just read.
Yeah.
Okay.
Yeah.
Sorry.
And that's okay. I was just going to ask if you would like to see it so that you could read it, because I know sometimes it's hard to pick up everything.
So to be honest, it's kind of blurry. So I'll just take whatever you read so.
I just entered the world of needing reading glasses. If you need to borrow some,
Okay. And you said E?
or it's under the E, but it's actually Roman numeral XII 13.
Okay, I gotcha.
Okay, so I would just like you to look in exhibit number 3 and tell me whether or not, and point out if it's in there, whether or not there's a program of fencing all stockpiles, roadways, pits, or refuse or waste areas to protect the surface zone's ongoing operations included in the mine plan.
There's no specific one outlined in that mine plan. I think like the mine plan is pretty general. I think it says, and you know, and this isn't verbatim, but I think it states that if there's an issue or something develops, it's at Black Hills Bentonite's discretion that they fence off the area, and whatever fence they build takes in like wildlife into consideration when they build the fence. I don't think there is no specific language in there indicating with regard to fencing what we would actually do on the Furnace property or the state lease.
Objection. This portion of the statute is not pertinent to this matter at issue. This particular section is not required to be provided to the landowner and has no bearing on whether the mining plan and reclamation plan have been submitted to the landowner.
Mr. Edwards.
Thank you, Mr. Examiner. I think it's very pertinent. One of the requirements that you're required to find under B12, if that's applicable, is that the mining and reclamation plan have been submitted to the surface owner, and this is part of the requirements of the mine plan, and also that the mine and reclamation plan is detailed so as to illustrate the full proposed surface use. And so I think those are requirements that this council has to find under B12 in order to find that an order in lieu of consent might be appropriate.
I'll allow it, and then the council will give it the consideration it deserves.
If you look at exhibit 3, which is the mine plan, and it's in the white binder. I'm sorry. Okay, and if you look at, I'm going to give you the mine plan page number.
Sure.
But it's that we also have numbers on the bottom for exhibit numbers.
Okay.
So it's MP 21 or exhibit 3-021. You take a look at that page.
Okay.
All right. And earlier you testified that you believe there was language along the lines of word deemed necessary by BHP regarding fencing. Is that?
Yeah. So, okay. So like right above that, like section, okay, there's section 6.2 occupied dwellings. So right above that, there's this sentence where deemed necessary by BHP, fences may be constructed above high walls in order to protect wildlife or livestock from the dangers of a fall. No conflicts with grazing are expected to result in conjunction with the development of mining activities. That's pretty much the sentence that I'm referring to.
Okay. So earlier when you testified, that's the sentence that you were talking
that's what
about.
I'm talking about. Yeah.
Okay. And that whatever that fencing is here would deal with only with high walls. Is that correct?
Yeah, just like it says, yes.
Okay. And the fencing would be at BHP's discretion.
In determining that, yeah, like I said, all this stuff is pretty general, right? Like all this language is general. Usually, like if something comes up with like specific landowners, it's usually like after the fact. You know, if a landowner comes to us and says, "Hey, I'm really concerned about what you're doing. Is there a way that we fence this stuff off or do something like that?" It's usually outside of this stuff where stuff like that comes up.
Mr. Gibson, in creating the permits, do you know what water sources are in the north half of section 1 on the Fernie Case property?
Is it okay if I look at the map?
Yes, sir.
Okay, so in terms of water sources, in terms of water sources for the area, I'm not aware of the water sources on Case property. I do know to the north in the state section, Murphy Creek runs through that area, and most of the year it does have, you know, water running through that area in the Murphy Creek. In terms of like water sources on Case lands, I don't know what's on there to my knowledge.
Do you know if Black Hills Bentonite was ever told that there are seep springs in the draws?
Well, I don't know what's been communicated to Black Hills Bentonite regarding that. You know, there could be, if there are seeps or something like that, those seep, anything regarding seeps, those usually like pop up in like the veg studies or the wetland studies. Usually like in those specific studies, our contractor will put like, okay, there's a seep in this location, and then usually it's an identified feature, so that'll get put on like a vegetation map that went along with that survey. So in terms like Black Hills Bentonite's knowledge of seeps in that area, I personally don't know of what seeps are in that area.
Okay.
Outside anything that might be illustrated on those baseline surveys, which I haven't looked at for a long time, so I don't know if they say that or not.
Okay. And do you know, you drafted the mine plan, is that correct?
What you see there on the map?
The written document that we saw at exhibit number 3.
So this mine plan it was developed by someone else, like the guy that was, I guess you could call in my position before I was in it. You know, he wrote this mine plan, I guess, you know, because it's general. So he wrote up the original document. And so like whenever I do stuff, I just change specific things within it to account for specific areas. I did not like do this thing from start to scratch. It was someone before me.
Okay. Do you know whether Mr. Case or someone on his behalf ever expressed the Black Hills Bentonite concerns with respect to the source water of Seep Springs?
In the conversations that I've had with Mr. Case, I don't recall anything of that nature, no.
And do you know whether or not there's anything in the mine plan that addresses any Seep Springs in that north half of section 1?
No, there's nothing in the mine plan talking about Seep Springs, no. Although in general, like this is just my assumption, but I'm assuming Seep Spring would be associated with drainages and things like that. So when mining and stuff, I try and stay away from drainages because the drainages control water. So, you know, when we're mining and doing stuff, or we place stockpiles, we try and avoid drainages, you know, unless they're insignificant ones that, you know, we try and stay away from them. So,
okay, thank you. I have no further questions.
Thank you, Mr. Edwards. All right, at this time, does the council have any questions for the witness? Yes, Council Member Lenz.
Thank you, Mr. Hearing Officer. Councilmember Lenz here. So, to your knowledge, does Black Hills Bentonite have deed reservations on all of the Furnicus property or just the 346 acre parcel that Bruce and Betty?
To my knowledge, well, to my knowledge, this 320 acres is all that I'm currently aware of. I mean, the Ferna cases have, you know, quite a bit of land in the area, but from just what I can recall, for what we have permitted at this time, under 248C, I'm pretty sure that this 320 acres is all that involves either Mr. and Miss Furnacase or the Furnacase Ranch.
Thank you.
Thank you, Councilman Lenz and Councilmember Badesum.
Thank you. So just a couple questions. One is, does the landowner ever get copies of the baseline vegetation and wildlife surveys?
Not generally. I mean, if somebody ever reaches out to me for specific stuff, you know, if it's within my purview, I give them whatever they ask for. If it's something that's questionable, then I'll go to management and I'll say, hey, Mr. and Mrs. whoever are asking for this, is it okay if I give it to them? Most of the time, they never have a problem, so I provide it to them. The baseline studies, unless somebody asks for them, they don't go to the landowners or anybody.
But they are public information with the DEQ because they were submitted to DEQ.
Yeah.
So if somebody requested from DEQ, they could get that information as well.
That is correct.
Okay. Then I have a question about the consent form. So if the landowner signed the consent form, would that consent only apply to what was proposed in this permit update? Because you said there was additional mining area on Furnacase's property that was not covered by this mine plan and reclamation plan that's set for a future date, but their signature on an approval, would that cover their whole 320 acres or just what was in this specific update?
To be honest, I don't know the scope of what that Form 8, you know, I can't answer that question. I don't know how the state interprets that Form 8.
Okay. Thank you. That's it.
All right, thank you, Councilwoman Badesum. Any other questions from the council? Councilmember Radakovich, you're recognized.
This is JD Radakovich. How many mines does Black Hills Bentonite operate?
So permit wise, we have about 5 or 6 different permits across the state. Within the KC area, we mine in like 5 different locations in and around KC, and there's the Tisdale area around Tisdale Mountain. We have mining through that area. There's 2 other mining sites located just outside the town of KC. There's this mining area where the Furnacase's property is. We call that like the Peterson Draw Murphy Creek area. So we do mining there. We mine just south of that. We call that the Willow Creek area. And it's over like about 5 miles, but you can reach one spot to the other. And then we mine, have another mining site that's in between or just north of Natrona, or just north of Casper, out in the Lone Bear area. And it's kind of halfway between Casper and KC and to the west. The Tisdale area, the Peterson Draw area, the Lone Bear area, the Willow Creek area, they all fall under permit 248C.
So,
and it's about like 31,000 acres.
And you handle the permitting for all these different locations?
That is correct.
And so lots of different landowners, lots of different mine sites, relatively.
That is correct.
There's a lot going on.
That is correct.
How many times have you run into a situation where consent isn't given or you haven't been able to establish a surface use agreement with the landowner?
To my knowledge, since I've been with the company, this type of situation has only happened one other time, and this was about 5 years ago, maybe, and that was with the 3T Ranch, even. There was, and Larry could probably, like Mr. Matson could probably expand on that more than I could. So this is just general knowledge. Black Hills Bentonite had a Bentonite lease agreement with the 3T Ranch Company. And there was just a lot of stuff going back and forth, I guess, between Mr. Crossingham at the time, who originally bought the 3T Ranch, and Black Hills Bentonite. And so there was disagreement between them, and it ended up where we had to do an EQC hearing like this. And in the end, we did get, in lieu of surface owner consent, to do mining in that area. And because of the area in specific that it was in, it involved mining claims. So because Mr. Crossing at the time wasn't, didn't give his surface owner consent, the BLM pretty much oversees what we do in that area. Normally they don't if there's a landowner involved, but because Mr. Crossingham didn't give his specific consent at the time, the BLM looks over things for him. Or, all that mining has been completed. It's all been reclaimed and seeded. And in the upcoming year, we'll probably go for bond release in that area. And in terms of with the BLM, they haven't had any issues with what we've done in that area.
Thank you.
Thank you, Councilman Radakovich. Any other questions from the council? Yeah, Councilmember Lenz.
Thank you, Mr. Hearing Officer, Councilmember Lenz here. So the 3T Ranch is very similar to the Fernicus property, where there are deed reservations dating back many, many years. And because you didn't get surface owner consent, you got the in lieu of consent. And that is required by your state coordinator out of Sheridan, that in order to get your mining permit application approved, that you'll either get a surface owner consent or in lieu of consent, regardless of what prior deed reservations exist.
To my understanding, that is correct. Because, I've had conversations with my permit coordinator as well as like the supervisor for District 3. And, so I've let them know of the situation where, because I basically went to them and said, I tried to get surface owner consent. I wasn't able to do it. But then I also provided them with the information regarding the deeds and all that stuff. And then after that, then that's where they were like, well, then I guess you'll have to get in lieu of surface owner consent then.
Thank you.
Thank you, Councilman Lenz. Any other questions from the council? Seeing none at this time. All right. Ms. Albertson, any redirect?
Yes.
All right.
Yes, just a couple.
All right, you may proceed.
I'll try to be quick so we can go eat. At the beginning of your conversation with Mr. Edwards, you had stated that the mine plan that we've provided to the council and that's sitting in front of you is pretty close to what's been approved by the state, correct?
That is correct.
Okay. The major things that were changed was essentially making it less specific.
Yeah, I guess you could say that because it just dealt with dirt movement.
Right.
Yeah, so yes, that is correct.
Okay, so less specific on the dirt movement and some protections for sage grouse.
That is correct.
Okay, but as far as the actual mining and the actual reclamation of the lands, nothing in that was changed.
Nothing changed.
So in essence, the Fernakis got a more detailed plan than what was actually approved by the state.
Yeah, if for taking into consideration dirt movement, yes, but they didn't get the thing regarding the sage grouse.
Okay. To your knowledge, did Mr. or Mrs. Fernakis ever call to say that they were never provided a map?
No.
Did our office ever contact Black Hills to say that Mr. Edwards was requesting a map?
No, not to my knowledge.
When you put those binders together, you typically include the maps in those, correct?
Yes.
And once that leaves your office and it gets into the hands of the landowners, do you know what happens to that binder afterwards?
No.
So is it possible there was a map included and somehow?
It's possible, but like I said, it's also possible that I could have forgot. It's highly unlikely because I do it quite often, but anything's possible. But like I said, I'm an open book, so if anybody requested anything whenever, if it's okay for me to do it, I provide stuff.
For the mining plan, you kept referring to it as being very general. Why do you create these to be so general?
I guess so we can use it for any permit that we're working on. So it has could cover anywhere that you wanted to do a mining operation. And then each one is just tailored to the specific area. And nowadays, most of that specific information, usually shows up in the map. That's where the differences arise, is each person's specific area. Not so much like what's in the text document.
When you submit mining and reclamation plans to this state, is there ever a difference of receiving surface owner consent when Black Hills is leasing the mineral, is operating under a lease versus when Black Hills owns the minerals?
Not to my knowledge. Yeah, not to my knowledge.
Okay. That's all I have. Thank you.
Okay, thank you, Mrs. Albertson or Miss Albertson. Mr. Gibson, thank you. You may step down. Okay. At this time, it is 12:37, and I'd like to take a recess for lunch. And what is the pleasure of the council? An hour, 30 minutes, 45? What do you guys think? An hour? Okay, we'll do an hour for lunch and we'll reconvene at let's call it 1:40. All right. Okay, we are now at recess.
That happens in depositions and we have to run out the door chasing people. Hey, leave that.
So, Mr. Gibson, where's hole in the wall at? Let's go over in here.
Oh yeah.
I'm going to leave this open so you guys can leave and come back in an hour.
You want to go that one? No, no, I usually just dig a hole down through it. Or
Okay, we are going to return. It is 1:39 p.m. We will resume. And Mr. Masterson, you have another witness to call. Is that correct?
That is correct, Mr.
Okay.
Hearing Examiner.
You may proceed with your witness.
We would call Larry Madsen.
All right, Mr. Madsen, please raise your right hand and respond to me. Do you swear or affirm that the testimony you are about to give in this contested case is the truth, the whole truth, and nothing but the truth?
I do.
Right. All right, Mr. Masterson, you may begin.
Thank you, and may it please the council. Sir, would you state your name and spell it for the reporter, please?
My name is Larry Madsen, Larrymadsen.
Would you mind moving that mic just a little bit closer? Thank you. What is your current role with Black Hills Bentonite?
I currently work part-time for Black Hills. My official title is Managing Director. I do basically special projects for the company.
And Mr. Madsen, if we could get you to speak up just a little bit, just so
Okay.
we can hear you in the back. Thank you.
All right, will do.
Yeah, pull it right. There you go. Thank you so much.
How long have you been with Black Hills Bentonite?
I went to work in October 1st, 1989.
And Black Hills Bentonite has been in business since 1947. Is that correct?
That's correct.
Is reviewing mining and reclamation plans a part of your job right now?
No.
You're familiar with them, though?
Yes.
To your knowledge, has Black Hills Bentonite ever had a mining or a reclamation plan rejected by a landowner before?
No.
To your knowledge, has Black Hills Bentonite ever had a mining or a reclamation plan rejected by the state?
No.
Can you give us an idea of the interplay between the state and Black Hills Bentonite during the run up to submitting an application and the permit?
Well, as Mr. Gibson said, he starts working on it. It takes multiple months and sometimes years to get all these studies done and get all the data put together. Then it's submitted, and then there's some back and forth. But once all that gets by, then they accept the application, and we just go from there. Then they approve it.
There have been some question apparently about the level of detail in the mining plan that's before this council. Using the livestock ip as an example, there's a statement in the current mining plan that was referred to by council. Tell me, what does Black Hills Bentonite do when they're in a situation like this where they're going to mine where livestock is grazing?
Well, we generally work with the landowner and the livestock owner and find out what their preference is. We don't generally have many problems with livestock. They don't generally go where there's no grass. And if we have high walls that we look are dangerous, we generally put up either fences or berms, because not only do we not want livestock in there, we don't want one of our people driving off the high wall or something like that. So there are safety things that are done, which generally keep the livestock out as well as anyone else.
Have you been successful working with landowners in this kind of area?
Oh yeah. Yeah. We've had minimal problems.
If a cow or a sheep is killed, falls into one of the pits, what happens?
Well, we generally just compensate the landowner, the livestock owner for whatever their loss was.
Do you see a lot of that on the mine site itself?
No, not generally. Most of our problems are haul trucks running over them on the road.
Can you give us an idea how many landowners you have worked with to get surface agreements or consent from in your time with Black Hills Bentonite?
I can't think of one. I mean, I've worked on some projects that we've done, but I haven't done it all myself. But we don't have very many of them, frankly. Most of these things are covered in the lease agreements, or in this case, like what we would consider the deeds or the.
Okay. Make sure you were speaking into
Okay.
that boom microphone. How many times, to your knowledge, has Black Hills Bentonite had to pursue an order in lieu of landowner consent?
Just one other time.
And that's what's been talked about already, the
Yes.
triple T. Okay. Let's talk about this particular situation with the Fernaccuses. The Fernaccuses. When did you first learn about that?
The first time I got involved in this was when I saw the letter from Mr. Edwards requesting that we negotiate with him on behalf of the Fernaccuses.
All right. And what did you do in response to that?
Well, we looked at it and we looked up the data and the documents, and we came to the conclusion that there really wasn't much to negotiate since we felt we had all the rights we needed to mine. And so that was the end of the subject on our part.
All right. What happened next as far as the Fernaccuses?
Well, generally, when we receive a letter from an attorney, we also get our attorney involved and let them start dealing with it. And that's what we did in this case.
All right. What about your personal involvement after that?
I wasn't really involved in it after that until we decided that we wanted to take a trip to Powell and meet Mr. Fernacus and discuss the issue.
And who's we?
Myself and the president of the company, Cindy Klimstra.
Can you, to help the reporter, can you spell her last name?
Her last name is spelled Klimstra.
Thank you. You decided to go up to Powell. Someone called in advance, I assume?
I believe Mr. Gibson did that.
You didn't just show up on their doorstep?
No.
And why did you go?
Well, we went because we weren't making any headway, and we thought we got to do something to get this thing off center. We didn't know Mr. Fernacus. We'd never met him or talked with him. And so we thought, well, let's go and find out what he's thinking and what his concerns are.
You went to Powell and met with him. And we know that that's August 24th of last year. So what happened?
Oh, we had a very cordial, nice meeting and a cup of coffee and got to meet with him. But we never really got any answers about what his concerns were. And he simply stated he wasn't going to sign anything. And so we said, okay, and we left.
Did you ask him why?
No, I didn't have to ask him why. His response was, I'm just mad and I'm not signing anything.
So you were ultimately, you were never able to figure out what he might want to negotiate.
No, he did not give us any indication of what he wanted.
Did you offer him any compensation for access or for approval?
Not at that meeting, no.
All right. During that meeting, did Mr. Fernicus ever tell you that you had to go through Mr. Edwards?
I don't recall him ever mentioning that.
Do you recall him mentioning Mr. Edwards at all?
Yeah, I think he said something about his attorney had tried to contact us, and then our attorney had dealt with him, and
Right.
that was really the end of it.
You had more contact with Mr. Fernicus after that, correct?
Right.
And
Yeah.
tell us about that.
Well, Mr. Gibson and I called him up because we got to the point where we thought we're going to have to file and try to bring it before this commission to get something to resolve one way or the other on this. And so we called him up for one last ditch effort to say, okay, hey, I like you, John, but I just as soon pay him and be done with this as pay him. So we offered to pay him, and I don't recall that we ever really got a response. I think we just got, no, I'm not signing anything, something to that effect.
Did you offer him a specific amount?
No.
When you reach a surface use agreement with someone, is it always only about monetary compensation?
No, lots of landowners want things other than money. Sometimes they do, but they oftentimes want things like, well, I want you to extend this road so we have access to this area, or we want you to build us a stock pond, or we want you to, do something like that. And so that's how we work out a lot of that stuff. And most of that is just verbally between us and them. There's nothing written. There's no contractual anything. We just do it to help them out. And that's the way it is.
But you never heard any specific requests from Mr. Fernicus?
No.
Did he ever ask you for a written surface use agreement?
He never asked me, no. Only what was in the letter from Mr. Edwards.
I'm sorry, say that again.
Only what was in the letter from Mr. Edwards.
Let me turn to one other subject. You understand that if granted, Black Hills Bentonite would need to post bonds with the state.
That's correct.
You're very familiar with posting
That I
bonds.
am. I work with the bonding a lot.
And the bonds that Black Hills Bentonite has to post, they have to be cash, correct?
Right. We're posting cash bonds.
Can you tell the council how bonds are calculated?
Well, every year, every permit has to have an update and an annual report. And we have to go in and we have to survey all the disturbance area. We have to calculate all the yardages that need to be moved to reclaim it, whether it's overburden or topsoil, and how much we estimate it will cost to seed it all. And then we have to calculate those based on tables that the DEQ provides us to come up with dollars. And then we have to add a 25% contingency fee to that. And then we have to add to that the expected disturbance in the next 12 months. And then that becomes the total that we have to bond for.
And when can you start the process then of getting a bond determined?
Well, we don't start the process until we're ready to include that acreage in our next 12 months mining. So if we have something out that we're not going to mine for 5 years, we don't have to do anything with that because there's no disturbance.
So it triggers that is 12 months out.
Right.
Do you accept that you have to post a bond?
We do.
And you've done it for decades, correct?
Yeah, the state changed the laws after the coal companies all started going bankrupt. And before that time, we qualified for what was called self-bonding. In other words, every year we had to give them audited financial statements, and they reviewed our financial condition and they reviewed our reclamation history. And then they came back and said, okay, you're fine. You don't have to do anything. After that, then we had to start either posting surety bonds or cash bonds. And we looked at surety bonds, but the surety companies are very reluctant to issue bonds. And so what they wanted was 100% cash collateral plus 1.5% fee. So that didn't make any sense. So we just cash bonded. And that's what we've done ever since the requirement started.
If this is granted, will you post the bond as dictated?
Yes.
That's all I have, Mr. Hearing Examiner. Thank you.
Thank you, Mr. Masterson. Mr. Edwards, the witness is yours for cross-examination.
Thank you, Mr. Examiner. Members of the council, Mitch Edwards with Nicholas and Tangeman. Mr. Madsen, I only have one question. Did your counsel inform you that they and I had conversations where I'd requested them to provide a surface use agreement draft to begin the negotiations?
I don't recall ever hearing that.
No further questions.
All right. Thank you, Mr. Edwards. At this time, do the council have any questions for this witness? Yeah. Councilwoman Badesum.
Yeah, sorry. So Councilmember March Badesum, I was curious, you said that you, at your, meeting, that you said that the, landowner was just mad. Do you know what he was mad about?
I do not. He never said what he was mad about.
Okay.
He didn't act mad at us, but he never said what.
Okay.
I have no idea.
But he said he was mad.
That's what he said.
Okay, thank you.
Thank you, Councilwoman Badesum. Any other questions from the council? No, seeing none. Okay, Mr. Masterson, any redirect?
This is John Masterson. Thank you, Mr. Hearing Examiner. No, I have no further questions. And Black Hills Bentonite has presented its case and we would rest.
Thank you, Mr. Masterson. Thank you, Mr. Madsen. At this time, you may step down.
Thank you.
May I have just one moment to confer with Mr. Edwards about whether Mr. Madsen needs to stay or not?
Yes.
While you,
yeah. You won't be presenting any witnesses?
Mr. Examiner, the witness that I had was Mr. Fernicus, and I asked him the questions on cross-examination I had for him, if they weren't already covered by Mr. Masterson. So,
okay. Well then, oh. Okay, so then at this time, we'll move to closing arguments. Ms. Albertson, Mr. Tolley, Mr. Masterson, you may proceed at this time with your closing arguments. You have 20 minutes.
Mr. Examiner, with your indulgence, can I have
Yes.
just
Take a minute to get ready.
quick, which is good.
Yeah.
My apologies to the council. I had anticipated Mr. Edwards would have a lengthy, extensive eviscerating cross-examination. And I just, all I'm trying to do is organize a couple of things I'd like to show you downtown.
Okay, well, while you're doing that, why don't we take just a 5-minute break and then we'll come back. So go ahead and take your time. We'll take a 5-minute break. All right. We are back from our brief recess, and it is 2:06 p.m. And Mr. Masterson, we're ready for your closing argument. You can proceed when ready.
Thank you, Mr. Hearing Examiner and members of the council. I appreciate your indulgence while I got everything straightened out. So here are the facts that you heard today in this hearing. Mr. Fernicus and his wife own this property. It is grazed by members of his family who run ranching operations in that area. Mr. Fernicus owns one cow. He has no plans on becoming involved in the industry again. He receives no money for those grazing rights. His income is Social Security and retirement from his work. And he has no objection to the mining plan or to the reclamation plans themselves. You've heard about the efforts that Black Hills Bentonite made. At best, I would suggest to you the failure to reach a surface use agreement is what they said in the movie, a failure to communicate. Perhaps balls got dropped, perhaps messages got missed, but ultimately no agreement was reached. And we can go back and forth as to why or whose responsibility that is, but that's really irrelevant. The fact is that no surface use agreement or approval was reached. That's why we're here. So this starts with what's Exhibit B. If I may move away, Mr. Hearing Examiner. This is on page 4 and 5 of Exhibit B in the binders you have.
Mr. Masterson, could you use the microphone though behind you? Thank you.
Oh.
Thank you.
This is the language in the deed, the conveyance that is at issue and that we feel drives this thing fundamentally and from the core. What you have is that the people who kept this, the Bentonite kept, shall at all times have the full and exclusive right to mine and remove. The grantee and the successors and assigns may enter, re-enter, use, and occupy so much of the surface as may be required, including drilling, stripping, overburden, depositing it, anything else basically that you need to do that is consistent with bentonite mining. And interestingly enough, without any liability and damages. Now we can think about why somebody would agree to this, because this is essentially everything. And we can speculate as to why somebody agreed to this, but the fact is they did. This is a 1957 deed, duly recorded. It is binding. It is public record. And it tells you that Black Hills Bentonite has what our statutes call the instrument of consent. Okay? The statutes don't ask for a consent in a particular form. They ask for an instrument of consent. I would suggest to you that this is an instrument of consent. That's what this gives. And Black Hills Bentonite fundamentally does not need to get the permission of Mr. Fernicus and Mrs. Fernicus. In fact, Black Hills Bentonite could probably sign the surface use consent agreement itself, because who has the right to consent? Black Hills Bentonite does, because it's theirs. Now, the next step in that deed-based analysis is that the Ferneckuses have no right to withhold consent. They just don't have it. And now that we look back on this, these umpteen decades later, maybe it was a bad move, maybe it was a good move, we don't know. But there it is. And that's binding and applicable. And it's binding and applicable on Mr. and Mrs. Ferneckus because they accepted the property subject to these reservations and easements. It's regrettable that Mr. Ferneckus and his wife did not know about these things, that no one informed him, but that is not an excuse. That does not mean you can waive a contractual agreement like this that is of record and public and binding. Now, I'm compelled to address the statutory argument. This is Wyoming Statute 3511-406B11. This is the statute that Mr. Edwards would like you to apply because, as I understand, Mr. Edwards believes that this gives a residential or agricultural landowner an absolute veto over the ability of a mineral rights holder to do his business. So, in order to invoke this, these qualifications have to be met. As used in this paragraph, resident or agricultural landowner means these things, and you have to have both. We don't dispute A at all. It's B that fails. We know from testimony and from common sense that there is no principal residence on this land, and certainly not a principal residence of the Ferneckuses. We know from Mr. Ferneckus's testimony that he does not personally conduct farming or ranching operations. We know that. Yes, he leases the property to family members under a handshake agreement, and that's fine. But this statute, to be invoked, you've got to personally be doing it, and he does not. Or, that's the last option, this is the last chance, receive directly a significant portion of their income from such farming or ranching operations. We know that that is not met either. And we know that because he said he doesn't get any compensation whatsoever for these grazing rights. I would suggest to you that you cannot apply this. The facts that you have before you are not only do not support this, they are contrary to this. So this one doesn't apply. So to continue down the statutory argument, if this doesn't apply, this one does. B12 of that same statute. There are 5 subsections. The last one doesn't count because it's about surface coal. These 4 requirements, if they are met, you shall issue an order. It's not discretionary. I didn't write it. It shall issue a permit if those things are met. The mining and reclamation plan have been submitted to the surface owner for approval. We know that happened. Mining and reclamation plan is detailed so as to illustrate. Today we heard some implication that it wasn't detailed enough. Well, you also heard why it's sufficient for the state, it's sufficient for the landowner, and that you cannot write a mining plan for any area of land and anticipate every possibility. And that's why you put these sideboards on it, these broad terms, and then within that, you work with the landowner. Third, that the use does not substantially prohibit the operations of the surface owner. There is no evidence, none, that the mining of this property will interfere with the grazing. You heard from Mr. Gibson that the area that is disturbed because of the way they do this is about 5 acres or less than 5 acres out of this entire parcel. You can't, there is no evidence to support that. And even thinking about it, the size of the mining operation and what they're doing cannot substantially prohibit the operations. The proposed plan reclaims the surface to its approved future use. Well, it does. I don't know what else to say. It does. You heard Mr. Gibson testify about what they do, the reseeding. They can't get their bond released, for a period of years after the reseeding to make sure that everything is taken. So if you adopt the statutory theory, that statute is the one that applies. I don't know how I could try to talk about all sorts of other things, but I think that is at its essence what we are talking about. I should throw out one other thing I'm remiss in not mentioning. Wyoming Constitution says that the state shall pass no law interfering with contracts. A deed is a contract, and we argued this in our reply to the response to the motion for summary judgment. And it's kind of just sitting there. So I just want to bring it up and remind you that that law is there. That's our Constitution. And it says we can't interfere with a contract. Were you to deny Black Hills Bentonite this after they've gone through the process, checked all the boxes, done all the studies, done the applications, you're violating, with all due respect, it's hard to say things like that, you would be violating a contract entered into in 1957. I thank you for your time. I don't envy your role. And I will reserve whatever time I may have left, Mr. Hearing Examiner, and I thank you.
Thank you, Mr. Masterson, and you have about 7.5 minutes left if you choose to use it.
Thank you.
Mr. Edwards, it is now your time. You may proceed with your closing arguments.
Thank you, Mr. Examiner, members of the council, Mitch Edwards on behalf of the landowner. First, want to address the issue with respect to Exhibit B and this deed from the 1950s briefly. The petitioner's argument, first and foremost, is that the statutes that we're dealing with here today violate the Constitution. Well, if that's the case, you're not the proper body to decide that. That issue on whether statutory legislation violates the Constitution, on whether that law interferes with the contract, is for the courts to decide. There should have been a declaratory judgment. Now, why else doesn't this body have the ability to, or the authority to interpret the deeds? If you look at Exhibit B, this 1950s deed, you're only getting part of the picture with what the petitioners are showing you. Paragraph 2 of that deed says, the grantee, its successors, and assigns, to the extent reasonably practicable, shall conduct stripping, mining, related activities in such a manner as to cause the least inconvenience to anyone at the time exploiting other minerals on said premises or carrying on ranching or grazing operations. It goes on then to talk about other rights that the surface owner has under this deed. And so for this body to get into it, they would have to look at this entire deed. all the rights granted, all the rights reserved, all the qualifications set on this deed to determine what rights were granted and whether this deed can be considered consent. Now, what I will say is this: the statutory framework under which this board operates, whether you're talking about B11 or B12, requires approval of the applicant's mining plan and reclamation plan. Now, I don't know how a 1958 deed that was written before the statutes were even written and before a reclamation plan was even submitted or prepared can constitute consent or approval of the surface owner to the mining plan or reclamation plan that's part of the application. It's just not possible. So this board doesn't even have to look at that deed and determine whether that deed is the consent, because it can't be. The statute requires, whether it's B11 or B12, that what the applicant has to include with its mine and reclamation plan is one from a residential or agricultural landowner granting the applicant permission to enter and commence surface mining operation, and also written approval of the applicant's mining plan and reclamation plan. Under B12, what the applicant has to provide is an instrument of consent from the surface owner to the mining plan and reclamation plan. If consent cannot be obtained as to the mining plan or reclamation plan or both, then the applicant may request an order in lieu of consent. Now, when we look at the statutory framework, because now we see that the deed does not control whether consent under the statute as required has been granted, because the mine and app plan and reclamation plan were never even prepared at this time. The first statute, section B 406B, sets out what the mining plan and reclamation shall include. In fact, it specifically says the mine plan and reclamation plan shall include the following. And then it goes through, starting with Roman numeral I, goes through a series of requirements that the mine and rec plan is required to have with the application. One of those is the B11, okay, consent from the agricultural landowner, or B12, consent from other surface landowners, required to be part of the application and mine plan. The other contents of the mine plan we're going to get into here shortly, but looking at B11, and this is the section that petitioners say that we say constitutes the right of an agricultural landowner to have an absolute veto. That's correct. That's what we say, because that's what the Wyoming Supreme Court said in the Belfouche case, is that when the statutes were adopted, that the legislature changed the common law of the dominant state, being the mineral estate, to the surface estate, being a dominant estate. And that this provision, B11, does not contain any qualified exceptions to obtaining the required approvals from the agricultural landowner. It was the Wyoming Supreme Court, not Mitch Edwards, that says that this provides an absolute veto. Now, when we look at the requirements of that statute, residential or agricultural landowner means the following, A and B. And Mr. Masterson, on behalf of the petitioners, acknowledged that the first section, A, holding title, is indeed met. That the Fernicase family, immediate family members, have acquired title prior to 1970, and this is shown in Exhibit 1 where Church Furnicus acquired the property in 1962, and then it was subsequently conveyed to members of his immediate family, resulting in Mr. Furnicus, Bruce Furnicus, and his wife currently holding title. The subsection B contains 3 different potential avenues on which one can be considered a resident or agricultural landowner. The first one, we agree, doesn't apply. That is that there's a principal place of residence on the land. There is not. The second one is or personally conducts farming or ranching operations upon a farm or ranch unit to be affected by the surface mining operation. That one, we believe, does apply. Now, what we did hear testimony is that Mr. Furnicus is old and starting to retire, and that he's sold currently his cattle such that he has 1 cow remaining, and that he has his cattle and had his cattle in with his other family members' cattle who graze that property and manage those cattle operations. While this statute says that to be considered an agricultural landowner, you have to personally conduct the farming or ranching operations, it does not say that by virtue of having old bones and not being able to ride the range, that you're not personally conducting the farming and ranching operations. It doesn't require you to have a certain number of cattle individually. What it requires is that there be conducted for you personally, ranching operations on that ranch unit. And that is occurring. There's no dispute that that is occurring. It's correct that Mr. Furnicus does not receive a significant portion of his income from those farming and ranching operations that are done through the Furnicus Ranch. His family members, but that's not an and, that's an or. And so in the case, if he were simply not running his own cattle or having his own cattle run and operations of his own conducted on that property, but he was leasing it to somebody else to run their own cattle, none of his whatsoever, then that would be the guiding question, is whether that provides him with a significant portion of his income. We believe that under the facts that are presented, that there's no question that Furnicus are indeed agricultural landowners under subsection B11. And that should be where the inquiry stops, because there's no exception to asking this body for an order in lieu of consent. It doesn't matter under that section whether they're going to bond, because it's not a bonding on statute. Okay? It doesn't matter whether or not what the reasons are for them not obtaining the approval. The question is, have they obtained the approval of the applicant's mining plan and reclamation plan? And that is no. Now, if this body believes that B11 does not apply, we agree that B12 then applies, because B12 deals with other surface owners that are not residential or agricultural landowners. In that case, the applicant would need to show the first 4 elements. The first of those is that the mining and reclamation plan have been submitted to the surface owner for approval. Now, this is where it becomes quite problematic, because what we heard is really some concerning testimony, and that is that what was submitted to the applicant was not the complete mine plan and reclamation plan. In fact, the testimony was that the map that wasn't included and is not included, incidentally, in any of the exhibits of either the petitioner or of the landowner include any of those maps. We heard testimony that that is the critical and most important part of the mine plan that should have been provided. It's not incumbent under this statute for the landowner to say, well, gee, you didn't provide me everything, or to go to the DEQ and to to look through the records. It's incumbent upon the applicant to submit the mine plan and reclamation plan that's required to the surface owner for their approval. Now, what is that mine plan and reclamation plan? What should it include? That's also contained in the subsection B. Roman numeral little v or 5 of that provides one or more maps are required. And it provides what those maps are to show. And there's a very long list of all the things that are required to be shown upon that map. That was not provided. Romanet numeral 7, v little I, requires that a contour map on the same scale as the reclamation map showing the extent possible the proposed approximate contours of the affected area after completion of proposed reclamation. In Exhibit 3 and Exhibit 4, or in Exhibit L, I believe it is. No, excuse me, not L. The exhibit that was provided by the petitioners, which is the mine plan, that is not included. It was not included to the landowner. Romanet numeral 8 requires that the proposed method of separating topsoil, subsoil, spoil pile, protecting and conserving them from wind and water erosion, et cetera, is required. Now, the testimony that we heard was that that was included in the mine plan that was submitted to the Furnicuses, but that wasn't the final mine plan. In fact, that particular portion was amended. And the argument from council was, well, you deleted 5 pages worth of stuff, providing less detail in what was actually provided and gone through and revised with the DEQ. That's more concerning to me. Why is it more concerning that that wasn't provided to the surface landowner? Because the mine plan sets out the requirements that the mining applicant has to abide by. And if it's contained, if specificity and detail is contained in that mine plan, that is what the applicant has to do. If that is deleted, now the applicant does not have to do that. They don't have to handle the soils in the way that they previously told the surface owner they were going to handle the soils. They don't have to put them in the place that they said they were going to put them before. They don't have to do all those things, and that substantially changes how a surface owner might view what the applicant is required to do. Instead of having that protection that the mine plan requires X, Y, and Z, we don't know now whether they're required to do X, Y, or Z. And if they're not required to do X, Y, and Z, that could change things drastically because now they can do something different. The mine plan is also required under Romanet 13 to include the procedures to avoid constituting a public nuisance, etc., including a program of fencing all stockpiles, roadways, pits, and refuse or waste areas to protect the surface owners' ongoing operations. No such thing was provided. We heard testimony today that typically Black Hills practice is that they deal with the landowner separately outside of their mine plan, and those things aren't included in their mine plan. And that they come into agreements like they came to with the Harlans, where that's in writing as to what they're going to do and how they're going to do that. That never occurred in this case. And it does not matter, because if the mine plan doesn't require it, or there's not a separate agreement, then it wouldn't be required of them. So it doesn't matter. All the testimony you heard from Black Hills about how they generally work with the landowner after these things are done doesn't matter if they're not required to do something in a certain way. That's why the statute requires that to be put in there specifically for the protection of the surface owner. Those are things, when it was requested to negotiate a surface use agreement, as was testified by Mr. Gibson, is typically in those agreements. But instead, we didn't even get a surface use agreement to begin the discussions. The other thing that's required, that's missing, is Romanet numeral 19, a projected timetable for accomplishment of the reclamation plan. Nowhere, if you look in Exhibit 4, which is the only place in the record that the reclamation plan exists, is there a timetable. There's not a timetable in the mine plan for when areas are going to be mined. There's not a timetable saying that this area is going to be reclaimed in, say, 2031 and moved on to. None of that is there. Those are all things that are important for the surface owner to have in their possession when they review it in order to give their consent and approval, which did not happen here. And so under that subsection 12, this council can't find that the mining plan and reclamation plan were submitted to the surface owner for approval. Because what we know is that what the DEQ might have reviewed and what they might have said was technically complete was not what was provided to the surface landowner. Romanet numeral B of section 12 provides that the mining plan and reclamation plan is detailed so as to illustrate the full proposed surface use, including proposed routes of egress and ingress. Well, that kind of goes back to the map that was not provided. The requirement to illustrate the full proposed surface use, including routes of egress and ingress, cannot occur without providing those maps. Now, what we also know, if you look at exhibit number 3, is there are numerous instances throughout the mine plan that revert to figures MP1, figures MP2, figures MP3, figures MP4, and etc. Those aren't included in the mine plan. And so all of these things is that an incomplete mine plan, regardless of whether it was what was submitted and technically approved by the DEQ, was not even provided to the surface owner. Those are the things that are required to provide the detail to illustrate the full proposed surface use. Now, little subsection C, that the use does not substantially prohibit the operations of the surface owner. I guess we just don't know. But what we do know is that testimony from Mr. Furnicase is that when these operations are going on, the cattle do not want to graze in this area. D requires the proposed plan reclaim the surface to its approved future use in segments if circumstances permit as soon as feasibly possible. Well, without that time period table showing when it's going to be reclaimed, how do we know it's going to be done as soon as feasibly possible? We don't. They haven't shown that. Is the requirement by the DEQ and the bonding that it be taken back to its future approved use? Yes. But this statute does not say, again, that if you bond on for reclamation or the reclamation plan is approved by the DEQ, that you're entitled to an order in lieu of consent. And so with that, regardless of whether this council looks at it under B11 or B12, this council cannot issue today an order in lieu of consent. And we would ask the council not to issue an order of lieu and consent and to deny the petition by Black Hills Bentonite. Thank you.
Okay, thank you, Mr. Edwards. Mr. Masterson, do you have any rebuttal?
I do, Mr. Hearing Examiner. Surprisingly.
Right, Mr. Masterson, you've got about 7.5 minutes remaining.
Thank you, Mr. Hearing Examiner. I have neglected to do this all day. May it please counsel. Counsel. What you have is two vastly different versions of what you heard today, and it is for you to determine which one is accurate and which is not. A couple things for you to consider. When we talk about the detail within the mine plan, the person who's been preparing these mine plans and reclamation plans for years for Black Hills Bentonite tells you this is the way these are done. This is their standard practice. There is nothing unusual about this. It was approved by the state. It was approved by the landowner. It is detailed. If you look at it, you will see, for example, it talks about pit by pit where they are going to mine. Exquisite detail. Where Mr. Edwards argues it's not detailed, I'd suggest to you that it can't be. For example, Mr. Edwards points to the reclaimed as soon as possible. Well, when you're not sure when you're going to be mining, you're not sure what may happen, you're not sure how long it will take to mine, and there's all that uncertainty, you cannot put a calendar date on when you're going to be done reclaiming. The issues about it not being detailed enough are misplaced, inaccurate, inconsistent with the practice of the state, and are a distraction from what you have to consider. This is the statute that Mr. Edwards insists is applicable, and I respect his position, but I could not disagree with him more. Personally conduct farming or ranching operations upon a farm or ranch unit. Mr. Edwards would have you expand personally conduct to the extended family, including nephew and grandnephew of Mr. Fernicus. That certainly cannot be the intent of this statute. It can't be the intent of this statute that any agricultural landowner in the state of Wyoming has an absolute veto authority over any subsurface mining. I mean, can you imagine the legislature really meant that? So, personally conduct farming or ranching operations. Mr. Fernicus, somebody conducts ranching operations. It's not him. He was last there a year ago. Before that, another year before that. He's staying out of the ranch and the cattle business. He has no plans on being involved any further. He has a handshake lease. He has no income from it. He is not personally conducting ranching operations. And were that not enough, let's take a quick look at the definition of personally, just for the heck of it, from the Oxford English Dictionary: in person, through one's personal presence or action by oneself. That's not personal. What Mr. Edwards is arguing, I appreciate. It is without basis in fact. It is without basis in law. It is illogical. To find that this mining and reclamation plans are not good enough would mean all the miners in the state of Wyoming have been acting under a wrong assumption for decades, including Black Hills Bentonite. That certainly can't be the case. Rather, the applicable statute, as we've talked, as you've heard ad nauseum, is that one. It was submitted to the surface owner. You heard about a map not being included. Well, no. You heard that what Mr. Edwards showed didn't have a map in it. You heard Doug Gibson tell you honestly, could he exactly remember whether or not he put a map in there? No, but it is his practice. He prepared 3 of these in total, and no one else said they didn't get a map. Could it have been lost? Could it have been misplaced? Sure. We don't have to jump to the conclusion that Black Hills Bentonite was trying to put one over on Mr. Fernicus or deprive him of any information. It was provided to him. And if it wasn't provided to him, if we don't like the version that was provided to him originally on August 24th of 2021, when we filed our petition on March 20th, 2024, this is in the record, you can take judicial notice of it. The Fernicus has received an entire copy with the mining plan and the reclamation plan. They also got another copy sent by the EQC on April 19th, 2024. So they've received it at least 3 times. In short, that's if you adopt the statutory argument, that applies. And every one of those boxes has been checked. We'd ask you to grant this order in lieu of landowner consent, allow Black Hills Bentonite to continue its business, and overrule the objections made by Mr. Fernicus. Mr. Hearing Examiner, I thank you. I thank the council. I appreciate your patience. And I am finished.
Thank you, Mr. Masterson. Okay. At this time, does the council have any questions for either party? Nope. Not everyone. All right. Seeing none, thank you all. This concludes this hearing. The testimony evidence is concluded. I will now turn over the gavel to Chairman True, the presiding officer.
Thank you, Hearing Officer Green. I now sort of open this up to the council. Do any members of the council feel a need to go into executive session to talk about any legal matters or questions that may have come up in the course of this contested hearing?
I make a motion to go into executive session for legal advice, Mr. Chairman.
Second. Do I have a second?
Seconded by Councilmember Blake.
Thank you. It's been moved and seconded to go into executive session. All those in favor, please say aye.
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 Any opposed? Okay, we'll go off into executive session and we'll be back. We're back and ready to go. Okay. Executive session. I'd like to open it up for discussion amongst the council. I don't know if anyone has to speak up first, or I will just sort of go down the line asking each individual council member.
Shane, we couldn't understand anything you just said.
Okay. How about now?
Yes.
Okay. I don't know what's going on with my mic today. Okay. Now that we're out of executive session, open it up for discussion amongst the council. If anyone wants to speak up, or I will just go down the line of each council member. Starting with our Vice Chair, JD Radakovich.
This is JD Radakovich. I guess I like the way council put it. It's a failure of communication. Seems like there's really no reason we should be here, quite frankly. If you guys could have got together and got this sorted out a long time ago. There's been almost years in this process now. And so it seems like from the evidence I heard, 11 doesn't apply, 12 does. Probably do a pretty good job of meeting that evidence. But I'm willing to hear what other people on the council have to say.
Thank you. Councilmember Bedezem.
Thank you, Chairman True. I agree with JD Radakovich in that it seemed that one of the first things that we needed to deliberate was whether 11 or 12 applied in this case. And I agree that I don't think 11 truly applies because we run a cattle herd, and I look at for when our ag lands, we have to document for tax purposes whether they're being used for agricultural purposes. There's usually a minimum financial benefit there. I think the lack of really truly personal involvement and financial benefit from it rules out 11, so that we're looking now at the items under number 12. And I have some concerns about whether the full, there's some question as to whether the full documents were received initially by the landowner, and we've also been told, well, they've received it several times since, but I'm not sure all that information was entered into evidence or not, and so would prefer to have some time to kind of look at the pleadings to be comfortable whether all those 4 items apply under 12 to this case. Thank you.
Thank you. Thank you, Councilmember Bedezem. Councilmember Blake. What say you?
Thank you, Mr. Chairman. Councilmember Stan Blake here. I agree with Councilor Bedezem on that. I'm real concerned of what Mr. Fanerkas received. Did he get everything, all the documents that he needed to make a decision with? And yeah, that's where I'm at right now.
Thank you, Councilmember Blake. Councilmember Lenz.
Thank you, Chairman True. Through the testimony and the evidence presented today, believe that Wyoming State Statute 35-11-406B, Romanet 11, was not met, which propelled us into Romanet 12. And in Romanet 12, I would like to take additional time to go through the testimony when the transcript is prepared and have additional time to go through the exhibits. And that would be my position on it. Thank you, Chairman.
Thank you, Councilmember Lenz. Councilmember Stafford.
Thank you, Chairman Truce. Councilman Stafford here. I agree with the previous speakers that 11 does not apply, 12 does, but we still need some more information on 12 to make sure that it met all the requirements.
Thank you, Councilmember Stafford. And Councilmember Green.
Thank you, Chairman True and Councilmember Ryan Green. Not to just kind of echo what the rest of the council said, but with Romanet 12, I think I certainly want to review the documents just to verify that those 4 points in there in 12 certainly have been met. So it would be my position to take the extra time to review the documents in depth to verify that those indeed have been met. So thank you, Mr. Chairman.
Thank you, Councilmember Green. And my comments are much the same. I am very well sure that Romanet 11 and 406B does not apply in this case, and that we are at Romanet 12. And I too, having gotten just these exhibits today, and some of them are rather lengthy and detailed. And I think it's important we make sure all 4 A, B, C, and D are met before we issue an order in lieu of consent. So I would agree that taking extra time and crossing all the T's, dotting all the I's, and make sure that we've got a full picture. So waiting for the transcript and reviewing seems to make sense to me. So I think moving forward, well, the council's, we've heard arguments from the parties. We've had the opportunity for discussion. Does anyone feel a motion?
Not sure exactly the right way to phrase this, but I would like to make a motion to table deliberations on this request for an order in lieu of consent till after we can review transcripts and the council members have the opportunity to review the documents.
Thank you. Okay, it's been moved and seconded. Do we want to have any what discussion do we have on this motion?
Chairman True?
Yes. Councilmember Bedesum?
I just wanted to mention that it does not prohibit the parties from continuing to have discussion while this is going on, since there will be at least a 30-day delay.
Definitely, yes. Yeah, I think it'll be important that any decision we make, one side's going to be happy and one side is not going to be happy. And I know one way for both sides to at least come away with something and both sides have some happiness is if they do come together and put together a deal. And would encourage both sides to take advantage of that time, in the interim while we are waiting for the transcript and thinking about it. So it's been moved and seconded to table this until we have a transcript. And at that point, we will set a date for continued deliberations after that. Do I have that motion? Is that sort of the motion?
Yes.
Encapsulate that correctly?
Yes.
Well, then we will take a roll call vote to approve or deny that motion, starting with Councilmember Radakovich.
Aye.
Councilmember Bedezem.
Aye.
Councilmember Blake.
Aye.
Councilmember Lenz.
Aye.
Councilmember Stafford.
Aye.
Councilmember Green.
Aye.
And I will vote aye as well. So we will wait for the transcripts to come out and spend time reviewing the evidence presented before us in this matter. So I want to thank everyone for your attention on this, and that concludes our agenda for today. Do I have a motion to adjourn?
So moved.
And I second that, Mr. Chair.
All right, moved and seconded to adjourn. All those in favor, please say aye.
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 Any opposed? Okay. The ayes have it, and the council is adjourned.
Thank you.